Assalamu alaikum, everyone. If you could please be seated, we will begin shortly. Good afternoon, everyone. Welcome to day 2 of Justice Project Pakistan's Reimagining Justice, a conference that focuses on public health and human rights-centered drug policy. Today, we will begin with our session on drug policies and personal liberty and addressing prison overcrowding. This session will delve into the issue of over-incarceration for drug-related offenses and explore human rights-based strategies that shift away from detention for minor drug-related crimes and alternatives to incarceration. Moderating this panel today is Mr. Haris Zaki. Haris is an advocacy specialist at Justice Project Pakistan. He has worked on a range of issues, including capital punishment, police torture, overseas Pakistani prisoners, mental health and incarceration, and drug policy. Haris, if you could please join us on stage. Our first panelist for today is Ms. Ambika Sadkunanathan. Ms. Ambika is a human rights advocate based in Sri Lanka. For more than 20 years, she has worked with persons and communities impacted by human rights violations and assisted them with assessing remedies. From October 2015 to March 2020, she was a commissioner of the Human Rights Commission of Sri Lanka, where she led the first ever national study of Sri Lankan prisons. Ms. Ambika, could you please join us on stage? Our next esteemed panelist is Dr. Saeed Kaleem Imam. Dr. Imam is the former Federal Secretary of Narcotics Control and a former officer of the Police Service of Pakistan with 33 years of Dr. Saab, if you could please join us on stage. Our next panelist is the esteemed Mr. Kadir Alam. Mr. Kadir is working as an Assistant Inspector General of Prisons in Punjab. He represents the Inspector General of Prisons and the Home Secretary in the High Courts and the Supreme Court of Pakistan and helps draft rules and policies on prison governance. He is also a member of the Provincial Parole Board, which determines parole eligibility and recommends cases to the Provincial Cabinet for release. Sir, if we can have you on stage. Joining us on Zoom is Mr. Rafael Barreto. Mr. Barreto is a crime prevention and criminal justice officer in the Philippines. Previously, he worked as a deputy coordinator in program Fazendo Judicia, a partnership between the National Justice Council and the UNDP. He is a member of the Advisory Committee of the Principles on Effective Interviewing for Investigations and Informing Gathering, Mendez Principles. Also joining us online is Mr. Saroop Ijaz. Mr. Saroop is a senior counsel at Human Rights Watch, Asia Division. Human Rights Watch published a seminal report on overcrowding in Pakistani prisons in 2023, titled A Nightmare for Everyone, The Health Crisis in Pakistan's Prisons. He is a faculty member at the Sheikh Ahmed Hassan School of Law at the Lahore University of Management Sciences. I now leave the floor to Mr. Zaki.
Thank you, Manya. Yeah.
actions that they take, the capacity needs expel a student if he's taking a drugs. The parents want that boy to be expelled because he might spoil their children. I said, no, you need to rehab him. You need to help him. You can't just throw him on the street again. He is going to go to some education institute. आप उसको नहीं छोड़ सकते. आपने उसकी मदद करनी है बेसिकली. और आप अपनी रिस्पॉन्सिबिलिटी से शेल्फ ऑफ कर रहे हैं कि since he has started taking drugs, so it's not their responsibility and let it be someone else's responsibility. Like we do with litter. You know, we like to throw the litter on the street and then we say the streets are not clean. So it's not over-policing, it's bad policing, I would say.
So, sir, what would you then recommend in terms of policy change or legislative reform that could at least start to counter this incorrect policing,
Now,
as you
having
call it?
said what they have been doing in the past, some of those phenomena and practices still prevails, and it will keep on prevailing as far if there is no accountability, and if people are not held responsible, if things are not brushed under the carpet. One of the worst things which is happening in the organizational setups or in the state pillars is when you find out that certain employees, you know, and certain actions that have been taken are not correct, you still don't want to actually take punitive actions, reprimand him, or call spade a spade. You want to brush him. The man is only held accountable if he is on the left, if he is not in your favor, if he is not in your happy shadow, he gets away. They say, show me the man and show me the rules. You see, and for police to improve, they have taken numerous steps over the years. For example, we have a narcotics policy, which just came on in 2019. We have a narcotics committee. We have intelligence task force. We have a lot of these forums which are coming up. And ANF is taking a lead. As a secretary narcotics control, I always said that everyone has to take an action. And you need to go after the suppliers, the people who are actually manufacturing it, the people who are actually supplying it. We just live across a country which produces 90% of the opium all over the world. So it was a transit route for some time, but now subsequently in times we became a victim. But we were not ready to actually train ourselves, build our capacity, get resources to see that this is coming and our children are going to suffer.
Thank you so much, sir. Having looked at that in the Pakistan context, Ambika, if I could come to you as an expert really on drug policy and having so much experience in this field, particularly as it pertains to prisons, could you talk a bit about the effectiveness of current punitive approaches to drug policy, particularly when it comes to drug use, and how this impacts people and their personal liberty? Thank you. Oh, yeah, I believe we have a presentation for Ambika, so if you could have that on the screen. Could we, yeah.
No? Okay, right. So your question about punitive policies and do they work? So I thought I'd share some numbers. This is from, one of your neighbors in the region, Sri Lanka, which has an ongoing operation, anti-drug operation, which is called Justice, but actually injustice is happening. So since 17th of December to 19th April, the total number of drug-related arrests in the 4 months, 93,639. But the majority of these people were fined and released. So they only had small quantities of drugs in their possession. If not, they would not have been fined and released. And if you look at the average length of sentence of persons convicted for drug offenses in 2022, it's 1 to 6 months. That is a sentence that is given to people who cannot pay fines, which means these people were in possession of user quantities. They were arrested, they were produced, they were fined, they couldn't pay the fine, and they were sent to prison. So this is clearly a contributing factor to prison overcrowding. The prison overcrowding since the operation began has hovered from 180 to 205%. But let's look at the drug seized, right? How much? Heroin, only 36.8 kilograms, and ice, 42.9. 4 months. So does the punitive approach work? Clearly not, right? Next slide, please. Oh, no, I am sorry. Okay. Now, what is the cost of imprisonment? Because governments understand numbers, and they care about cost. If we look at, once again, Sri Lanka, the average cost per person per year is 447,796 rupees. So for a population of 29,000 plus, which is the average at any point, the per day cost is 36 million. Now, imagine if they channeled that towards community-based voluntary treatment options, the impact that would have. If you look at the national budget, the Ministry of Defense, because the defense is also involved in not only drug control, but also drug treatment in Sri Lanka, their national budget is 129 billion rupees. And the Ministry of Public Security, which is police, 116 billion. But how much of the public sector salaries does the health ministry get? 17%. But the majority goes to the Ministry of Defense. So we can see where, and Harm Reduction International has this Divest Invest project, which is about following the money. Let's chase the money. When you chase the money is where you find the evidence to say this does not work, and actually states are wasting money. Once again, this also is about the Auditor General. When they audited the prisons, they found they're looking at prisons again, this is what causes overcrowding. Now, quickly, I think alternatives to incarceration. How much time do I have? Whether we need to incarcerate at all for certain offenses, like personal drug use. Is it an offense or is it a health issue? A public health issue that we need to deal with through the Ministry of Health and other health options. Now, in Ireland, for instance, they have an adult cautioning scheme for cannabis, where the prosecution, when the prosecution is not in the public interest, the police can decide whether to prosecute or not. But once again, this is also situations of vulnerability. They cared for minor children, or senior citizens, or persons with disabilities. So here, and this I think is important because it's looking at it through the lens of criminalization of poverty. Why, even a person who's dealing, why are they dealing? Are they from a vulnerable, marginalized, discriminated against community? So you can see there are also other, I can also share this, other laws, 2 other laws, which also focused on women who were vulnerable and reducing sentences and reducing the time that criminal records are kept, because that also prevents people from accessing employment, for instance. When police reports are issued, that will be included in that, and they might not be employed. Then this is a new thing and rather radical, but I thought I'd just mention it anyway, now that was in Costa Rica, that was just about reducing the sentence. British Columbia has started in Canada from 2023 to 2026. They have piloted, this is a pilot initiative that they've started to decriminalize opioids. And so adults found in personal possession of any of these drugs that adds up to a total of 2.5 grams or less, they won't be subject to arrest or criminal charges. Instead, they will be offered information about health and social support, including making referral to local treatment and recovery services. So what they did to prepare for the implementation, you will see, is a lot. It was about training the policemen. It was about also educating the public about this. There's quite a lot of resources and continuing engagement with the stakeholders. Quite a lot of public resources that have gone into ensuring that it can work. And also they're continuing to invest in mental health and substance use support. And federal and provincial governments working closely together to evaluate and monitor implementation. That is something that is so important. Changes to also law enforcement practices, because the police are used to working in a certain way. So it would require quite a change in their mindset. So investing resources to also ensure that happens. And monitoring, as I said, extremely important. But the point here is that it's not enough to just pass a law or to say we're going to decriminalize or the police must not arrest. There is quite a lot that needs to happen structurally for it to be a success. But as I said, it is new. This is just a pilot. It's just begun, so we don't know how it will be rolled out. Yeah, thank you.
Thank you so much. Yeah, I've just one quick question before you leave. I know you have to, unfortunately, leave us. So based on what Ambika said, what role do you think the police could play collaborating with healthcare providers or with the health services in Pakistan to sort of move away from this model of putting people in jail and move towards a more health-based thing in light of the best practices that we saw highlighted?
We already have an inter-task force agency, which comprises of about 35 law enforcement organizations. And I'm sure that is one of the platforms where we can, discuss this new findings of paradigm, which we have just shared by one of the panelists. But what police is doing, or what are some of the things in the pipeline, and what they need to do is, of course, they need to have specific cells. You cannot do generalized policing in this modern times. With the use of AI and IT technology and all, you need to specialize this working. That is one way of moving forward. Secondly, you have to enhance your forensics. It is so important that the forensics is easily available and it's quick to respond and quick to actually help in deciding the due process and law. Thirdly, capacity building, providing them resources, no interference, and holding them accountable. At the same time, giving them that understanding of the modern meta minds and those ice and ecstasy, the new drugs which has come in this part of the world. Again, police intelligence setup has to be geared up to ensure that they get to the supplier And they must also ensure that the rehabs and the training centers are not purely for commercial purposes, but it is actually out there to help people. There are around 800 therapy centers, which I understand around in Pakistan, and most of the hospitals in Pakistan have been declared that they need to have these beds for the addicts. Certain laws have been made, but those are just laws, I would say. We need to make them more efficacious. We need to ensure that all hospitals, when they are saying, or all 116 prisons in Pakistan, when they're saying they have facility to treat these rehabs, these patients who are addicted and now have committed a crime, do they have resources? Do they have beds? Do they have those trainers and actually health officials who can bring them back to life? Those are some of the important things. I'm so sorry, I would love to have continue, but since I have a prior engagement at 2, so my apologies to the audience, but I would be here tomorrow, and I would join the session
Thank
with
you so much,
Sarah's
sir.
permission. Sarah, thank you very much once again, and my
Thank you so
apologies
much,
to
sir.
all the audience. Thank you very much.
Thank you, sir. So, having heard a lot about policies and stuff that we can do before the person even ends up in jail, moving to the actual prison system, Kadir Saab, could you, in your experience working in Punjab's prisons, which has a massive prison population and a massive population of prisoners who are in there, who are either facing or have been convicted of drug offenses, so in this sense, could you share some reforms or initiatives that you have been a part of or that Punjab Prisons is currently doing to address the challenge of inmates who are in jails for drug offenses in terms of overcrowding? And yeah, thank you.
Okay, thank you. Thank you very much for this invitation, and thank you for the host of the organizations. Before I answering to your question, I will just request you to just share some statistics of the Punjab prisons. Can I? Okay, we Punjab prisons have 43 facilities, and we classify the prisons as a central prison and a district prisons, and we have also the special prisons for the females. There's one jail. We not call prison, but it is called jail under the law. And we have 2 Boston institutes. There's a meant for the juvenile prisoners. So just to have a quick look before I'm going to the statistics. You must understand we have not the classification on the basis of the intensity of the crime. That means category 1 prison, category 2, 3, no. But we have only the district prisons where all sort of prisoners are there under trial, the convict, the death row, and the female and juveniles. So it is sort of a prison complex, you can say. So this is for the international audience to make them understand. Here is a prison mean, that is the under trials are there, the convicts are there, the death row prisoners are there, the civil prisoners are there. So now I move forward. If you look at the population of the prisons, this is a Punjab prison.
Hello.
Sorry. We have 62,000 prisoners, and this is a recent data that was it stood on 9th April 2024. If you look at this, their status, the majority of them are the under trial prisoners, and its a number goes to the 45,000. And if you go to the UCCP mean, the unconfirmed condemned prisoners mean those who are facing the death penalty, but their appeal is pending with the Lahore High Court. And The next is the CP mean, the confirmed prisoners, which we call as condemned prisoner as well. So this is a 273. It also includes those who has filed a mercy petition to the President of Pakistan. So this is the general statistics. So now I come to the how many the prisoners who are charged with the drug offenses. If you look at this chart, so we have this total number stands at 12,332. So majority of them are the under trial, and they are 10,893. So if you look at the 9A mean, that is the Control of Narcotic Substance Act 1997, it's section 9A, then 9B, 9C, 9D, E, F. The further questions may be why it is 9A. It depends upon the quantity which is in the possessions recovered by the police or law enforcement agencies. So this is the classification basis of the possession, not the basis of the addiction. This is also one of the lacunas under our CNSA, Control of Narcotic Substance Act 1997. So if you look at the total population of the Punjab prisons, and the big chunk of the under trial prisoners, they are involved in drug offenses. That is the 12,000. Okay, that's good. There's the convict prisoners. So the first one is under trial, the convict, and under the convict we have the UCCP, and on top of it, this is the death row prisoners, what we call as condemned prisoners. So there's a convicted, yeah, convicted prisoners. So those who are undergoing the imprisonment, mean 14 years or 25 years, so that is called the convicted prisoners, okay? So what are the thesis, what the corollary of this the statistics says, the majority of the prisoners are the under trial, and almost this is 1/4 of the population, they are related to the offenses with drugs. Okay, the UCCP is just as the name reflects, unconfirmed condemned prisoners. The sentence of death is the only sentence which is subject to the confirmation by the High Court. So when it is confirmed by the High Court, so then the effectees can file appeal to the Supreme Court. So it is not appeal. This is a mean that is subject to the confirmation. The trial court write the judgment. This death sentence is subject to the confirmation of the High Court, okay? So let me move to the question. So the question was asked, what Punjab prison has done for the reformation and the rehabilitation of the prisoners. Sorry. Okay, one more stats, which I'm going to share. Those who are aware of the prison system in Punjab or Pakistan, district and session judge pay a monthly visit to a jail. And during his visit, he releases the persons, rather inmates who are involved in petty offenses. And this is the statistics of the 2023, and the total number is 9,452. These are the prisoners, these are the rather under trial prisoners who are involved in the petty offenses released by district and session judges. If we look at the offenses, the majority of them, rather 99%, are facing the charges on 9A and 9B, mean they are the drug addicts. So all of them are the drug addicts. And this is here, what I think, what I will suggest to the police authorities and all the stakeholders of the criminal justice system, especially the judiciary, they should look over it. this is a sort of a vicious circle, a futile effort. Just it is the game of numbers. So every month we are releasing the person, they are coming again. The police authorities, the SHO, tell the drug addicts, okay, you are going to send to the jail and you will be released under the trala. Because I also worked as superintendent in jail, I know the basic terminology which the prisoner used inside the jail. So the drug addicts, they say, okay, if somebody, I used to ask the drug addicts, okay, in what case you are there? They say, Sharji, mein trala mein hu. The trala means that the police authorities told him, okay, you are going to be sent to the jail and you will be released in a couple of days when the district and session judge will visit it. So this is the number. This is almost 10,000. So this can be sent to the rehabilitation center instead of sent to the jail. We should not mean just to for the sake of formality. Just my suggestions, yeah. Now, the question is what the prison authorities are doing with the prisoners who are charged with the drug. Okay, there are two types of the prisoners. The first are those who are charged with 9A and 9B. We treat them as a drug addicts. And we classify them in a different blocks. And there is other category of the prisoners which are involved, whether 9C or 9D or E and F, we treat them as a drug traffickers. So this classification is observed in all prisons. So this is the very important which is going on. And other important thing that for the prison authorities, the classification of the prisoner is very important. And now the classification system based upon the offenses which are reflected in the commitment warrant. If somebody has been charged with a murder, so that would be confined in the blocks meant for the murderers. And somebody is charged with a theft, that will go there. But this moot point is somebody is charged with the murder at the same time he is a drug addict, how we will identify. So here it requires a scientific technique, what we call it as biological marker. So this was not working in Punjab prisons, but due to the blessing of the judgment of the Lahore High Court, and the judges are there, so I just made the suggestions there. So, and we have introduced now the urine kits. Urine kit says just we dip the one minute, we do that specimen of the urine, and it identify the 12 different substance abuses. So now this is happening regularly in Punjab prisons. And since rather 2023, in the year 2023, it was almost 12,000 tests were conducted and almost 5,400 they were positives. So in different substance abuses were identified. So this was the new thing which we can say for the world, for the best practices. It might be not new, but especially in Pakistani system, criminal justice system, it was a new interventions. Okay. Next important thing is, once the drug addiction is there, so we have the confinement area because we have the overcrowding in different jails, especially in Central Jail Adiala and the Central Jail Lahore and Camp Jail Lahore and Multan. These are the high density prisons. So there, especially the blocks meant for the prisoners, they are overcrowded. So the prison authority try to make them clean, and they do special activities, do special exercises. So that's fine. But again, there is a room for improvement. I don't say that everything is fine at the utopian state in the prisons, but the prison authorities are trying their level best to provide the basic facilities and especially their hygiene. Cigarettes are prohibited there. So these are the measures there. But one more important thing, especially there is a big challenge for those prisoners who have their high dependency upon any substance. So those having higher dependency, so when the person does not get the required quantity of the substance, so it having a very, very severe symptom. And this term is called withdrawal syndrome. I repeated, the withdrawal syndrome. So for these sort of patient, I'm not using this word patient because the prisoner also used to say, sir, मैं थोड़ी सी दवाई लेता हूँ. They never say मैं drug addicts करता हूँ. कहते हैं कि मैं दवाई लेता हूँ. थोड़ी बस लेता हूँ. So this is to treat those prisoners who are having high dependency and those having the withdrawal syndrome. The Punjab prisons that the government of Punjab have introduced development schemes, what we call it 20-bedded scheme in 17 jails. So in 17 jails, 20-bedded hospitals have been constructed, and now here challenge would be there because civil works has been completed. Now the challenge would be to get the medicines and the doctors. So I hope we will try to cope with this issue.
Thank you, sir.
Yes, other important intervention, that was again the order of the court. That was screening of the drug addicts, and especially the basic questionnaires, what we call it. Basically, this was modeled on the 8 questions of the WHO. They're very renowned test, it is called ASSIST. So we adopted those questions for the screening of the drug, and this is based upon the questions. So it is a purely adoption of the WHO guideline. So another important thing, when somebody is being treated inside the jail and if he is released, so what would be his and her fate? In this regard, we are aware of the aftercare. Aftercare means that somebody is being treated inside the jail. If he is released, he will get the same treatment outside the jail in a public hospital. So in this regard, we have introduced, rather inserted amendment in Pakistan prison rules, and this amendment is under Rule 18, and under the 15 we have the profiles of the drug addicts, and especially in 18, it is the responsibility of the superintendent jail and the medical officer. When a person having the high dependency are being treated inside the jail, he will refer it to the hospital, to the public hospital, to the rehabilitation centers. This is one of the achievement of the Punjab prison. I hope it will sustain as well. Okay, what would be the solution? What are my recommendations? The first recommendation, the law is there. This is CNSA, Control of Narcotic Substance Act 1997. It's section 52 categorically say the drug addicts must be registered. They must be awarded a card, and they should be hanging those cards, and this is the sort of their identification. The second, again, the suggestion that is based upon the national legislation, and that is a section 53. It's the responsibility of the state to rehabilitate, to establish a rehabilitation center, to reform those drug addicts. This is the second responsibility, just reminding it. So the third important proposal on my suggestion is maybe you people are aware of Bakshi Khana. Bakshi Khana is a place where when the prisoners are fetched to the court and they make a stopover there. And this place is being administered by district and session judge and as well as the district administration and the police. But this is the worst place. So you people will say, I'm from the government, why I'm not doing it? But I'm highlighting this issue to all the district and session judges where I can do it. So this is the place where the prisoners get every bad things. The drug addictions is there, and the mobile phones are there. So overall, the conditions are very bad. So when they come inside the jail, say they swallow it, or they say try to smuggle those different substances inside the jail. I don't say, I'm not going to defend the prison authorities are not involved in smuggling of drugs, but there are, the black sheeps are there. But at the same time, this movement court production movement provide ample opportunity for the prisoners to exploit this different type of substances and so, what we call drug abuse. Next important thing is, which would I say, not last but the least, this drug addicts, they should not be sent to the jail. And here my suggestion is, there should be amendment in section 53 of the PPC, and there should be alternative to imprisonment. As we know, these theories of crime and punishment have been changed, and still we are sticking to section 53 of 1868 Penal Code that categorizes, enumerates 10 different kinds of punishment. I appreciate the Jeremy Bentham's theory that which this Indian Penal Code was modeled. The Law Commission did a wonderful work in their age, at that age, but now the times have been changed. This is 2024. The theories of crime and punishment have been changed. So in the early 21st century, there was a questioning on the working of the prison. They say prison doesn't work. Everybody was thinking about we should go for the alternative to imprisonment, mean towards a fine, towards attendance, and to weekly or monthly attendance, and they also go to the community service, and they go to the electronic this which we call it electronic monitoring, house arrest. So these are the ways which are available. At the present, the judge have no option except those 10 sentences, 10 different type of sentences, and one of them is imprisonment. So that's fine. I conclude here.
Thank you so much, Dr. Saab. That was excellent. Now moving to our online panelists, Sarup, if I could maybe just club one or two questions together for you. As the author of a very important report that Human Rights Watch released last year on the health conditions in Pakistan's prisons, what insights could you share in the research that you conducted around the report and generally on health conditions in prisons for persons who use drugs? And what sort of reform or actions would you propose that policymakers can take to improve those health conditions or counter some of those issues? Sorry, Sarup, I think we're having a little audio hiccup. Just a second. Can you check if your thing is mute? I think you're unmuted. Raphael, can you, maybe it's an issue from, just to check if it's not on our side. Okay, yeah, we can't hear you either. So, yeah, so, yeah, so we'll just come back to you guys on Zoom. Very sorry about this. So if we look at punitive models of drug policy, Ambika, and I think this is something that Qadir Saab also spoke a lot about, something Kaleem Saab spoke a lot about, and that you also spoke a lot about, was and there's this undercurrent of criminalization of poverty. You talked about so you talked about the types of persons who are most affected by these systems, and most people who are mostly in jails. Yeah, the mic, I think, turned off. Okay, so yeah, so what are some best practices and international standards that could counter this issue of criminalization of poverty? And generally, what insights could you give us about this criminalization of poverty when it comes to drug offenses that we see so often? So Great. We'll just come back to Ambika. Afterwards, Sarup, if you could go ahead. Thank you so much. My apologies.
Yes. I assume everybody can hear me now. So good afternoon. Thank you, Arif. Thank you to Justice Project Pakistan for hosting this very important conversation. I'm really sad I couldn't be there in person. In terms of your question, I think a lot of important insights have already been made by Ambika, by Kareem Aftab, by Teresa. In terms of Human Rights Watch did, and Human Rights Watch in doing this research on access to healthcare in Pakistani prisons, actually built upon and utilized a lot of work that Justice Project Pakistan has done. And because in JPP, I should say this here, in terms of prison rights in Pakistan, has really been a flag bearer, has been a star in this. So after saying this, I think there are multiple problems. In terms of looking at healthcare in Pakistan, the first starting point is that Pakistan is an abysmal healthcare system generally, which is amplified in a more acute form in the prison system. So Pakistan, and that's just WHO just released very recently released data on healthcare spending for all 189 countries in the world, and Pakistan spent 0.84% of its GDP in 2021, the last year the data was available, on healthcare, which means Pakistan ranks 176 out of 189 countries in healthcare spending in when measured relative to its budget, to its national economy, and 170 when measured according to its budget. So there is this general problem. In the prison system, the problem is amplified, and in that subcategory, I think the problem is amplified for people who are incarcerated for drug-related offenses. And there is a lot of findings that we had in terms of what is the level of investment in infrastructure in access to healthcare in prisons, which is the shortage of doctors, the shortage of prison hospitals, the shortage of equipment for prison hospitals, of essentials like insulin, etc., etc. And then there's the level of the structure of it, which is despite a lot of sort of or some reform attempts, some which Teresa outlined also, Pakistan's prison system is governed by a colonial structure, which is the dominant theme of the Pakistan prison system. And then you can measure them on the international yardstick, which the OHCHR report also talks about the cross level of things like the Mandela rights, things like Bangkok rules, the Mandela rules and the Bangkok rules. But what we found is the primary recommendations for improving access to healthcare in Pakistani prisons are actually recommendations which improve the dysfunction of the criminal justice system in general and the prison system in particular, which is early release. The single largest reform that the Pakistani authorities can undertake for addressing overcrowding of Pakistani prisons is reforming the bail laws to bring it in line with international standards. It is more than investment, more than building more prisons, more than building state-of-the-art prisons. It is just to have sentencing guidelines, just to grant people bail as a matter of policy. So I think that in itself is one of the most critical reform attempts that Pakistan can do. There is what Teresa I think talked about is Pakistani laws, and again, this work's been done on that by MySAR and by JCG. But Pakistani laws needs to be brought in line with international standards such as the Mandela rules, the Bangkok rules. There has to be transparent mechanisms of accountability uh, for for functionaries who do not uphold prisoners' rights. Uh, and Pakistan has to, and the larger picture is, of course, the Convention Against Torture and the anti-torture law for implementation of that. But the idea of looking at the drug-related offenses, and I think part of it is just because it, Khadija gave the figures, I think 12,000 prisoners, is that it's not as if those judgments would have said in most cases, or the authorities felt, or the investigating officer felt, that this person in particular issue posed, in overwhelming majority of the cases, posed a threat to society beyond themselves. That is predicated on the idea that this person is a drug addict and needs to be taught a lesson. It's not predicated on the idea that serves an imperative. And there is, so when we talk about public health, public safety imperative, I think it's been a very long time since the Pakistan government, and there are many other governments who are in the same boat, have even made that argument. So it is the criminalization of drugs in many ways, or sort of the clampdown, the militarization, the war on drugs, butyrate war on drugs in the Philippines being an acute example, but in Guatemala, in Colombia, around the world, and also in the region, also is part of the coercive structure of the state, right? It's part of asserting yourself. And when there's no space, there is, I mean, if there is no moral argument that would prevail, there is a practical argument. And the practical argument is that not only it's not making anyone safer, not only it's not making anyone healthier, what it is doing, it is actually doing the opposite. It is making prisons overcrowded. It is making
Hello.
people less safe.
Thank you, Sarup. Yeah, thank you so much. You mentioned the Philippines. I believe Rafael from the UN Office on Drugs and Crime has a quick presentation on UNODC's work in the Philippines. So I'll let Rafael have his presentation, then we can have a quick question for him as well. Yeah. Can we have that on the screen, or would you want to share your screen, Rafael? Are you muted, maybe? Or is it on our end again? Okay, I think you might be muted. Yes, yes, we can hear you now. Yes. Yeah, perfect.
I hope this is, I hope you can see it.
Yes, I think everyone can.
Okay. So thank you very much. First of all, it's a pleasure. Really appreciate the invitation to participate in this very interesting and engaging conversation. I've been personally learning a lot about the Pakistani system, and I hope that these comparative approach from the Philippines might be also helpful as we face very similar challenges as Pakistan based on the discussions held so far and the background documents for this very interesting event. I understand we're pressed for time, so I'll try to just do a short, very short introduction of our work. focusing on health, security, and justice. This materializes into 5 pillars of our work, but for the purposes of our conversation today, I'll focus closely on 2. And that's part of our work is to connect how the drug policy interconnects with the criminal justice system and prisons, and how we've made it a loop of also trying to implement reforms related to people who use drugs and are affected by criminal justice in general through criminal justice reforms, and sometimes through drug policy reforms, which tend to be a harder approach for change in the Philippines based on legislation and the political context in the country as well. But before going to the specifics of our work, I'd like to highlight something that is often the case that we do. Our work based on the Nelson Mandela rules, the minimum rules, I was very pleased in some research I did yesterday to learn that Pakistan was involved in the first expert group meeting that took place in 2012. And I think this is also an argument to make that the Nelson Mandela rules were indeed drafted. There was a revision from the previous standards with a lot of engagement from countries in the global south. And many of the provisions and the ideas that are currently part of these rules have been experimented or idealized or conceptualized in countries throughout the global south. In particular, the Philippines is also part of the working group. So these are 2 countries that we're connecting today also who aspire to achieve many of the standards in the Nelson Mandela rules. Also, another document that is very important for the work that we do in UNODC is the UN Common Position on Incarceration. This is from 2021. So this was published in the context of the COVID-19 pandemic, and it really highlights the importance of tackling the overuse of incarceration, as it was saying, over-incarceration, as it was said by the panel previously, but also the excessive length of pretrial detention, and highlights how it's a massive problem in several countries. In more than 45 countries, it outnumbers the number of prisoners who are convicted, and in 14 countries, it's more than 70% of prisoners. The Philippines is the biggest challenge. Is the Philippines is part of this second group. More than 70% of the Philippine population is in prison with pretrial detention. And the common approach that's stated in this common position is to shift policies toward prevention and alternatives. So thinking about other ways to tackle incarceration in general, crime, but most importantly, the drug issue. Also, in connection to overcrowding and the prison system, these are 2 main angles from both of our main areas of work in UNODC, both from the drug policy side, but also from the prison and criminal justice side. The handbook to reduce overcrowding is an extremely useful tool that I would recommend. Just consulting the ideas that are there that might be interesting insights for reform and for the work being done in Pakistan. I just want to briefly go over some of the main area for this conversation today, which is our work in the Philippines. And a bit of context, the Philippines is currently the 3rd most overcrowded country, most overcrowded prison system in the world. It's a massive challenge. The average overcrowding rate is 370%. It is also the 11th on the total number of persons incarcerated. So there's a massive absolute number of people detained. And in the last, in these 6 years from 2015 to 2021, has grown over 75%. And then, as I mentioned, more than 70% of prisoners are in pretrial detention, and 80% of those are for drug offenses. So that's a massive challenge connected. You cannot talk about prison reform in the Philippines without tackling drugs. This is a very short timeline of what we've been able to achieve in the last couple of years. So I'll highlight 5 main areas. The first is a de-bureaucratization process, reducing the red tape for releases with the Supreme Court, an approach to prioritize release of elderly and people with healthcare, serious health problems, changing issue a circular that stated that there was no longer needed to wait for court order for release if the person had served their minimum imposable term. That was very important for the pretrial cases, and it had a very big impact for people accused of drug-related offenses who are probationable. That is, drug use may get a penalty of up to 6 years. So this has been very, very beneficial for earlier releases of people accused of this type of offense. The second aspect that is worthy highlighting is a move on the convicted prisoners to release to prioritize release rather of vulnerable groups. And this is something we've advocated for especially elderly prisoners, and making a point to highlight that there's a phenomenon of aging out of crime. So older people commit less crime, and therefore releasing older prisoners pose a minimum or no risk to public safety, and therefore it's recommended as a priority group for release, and also connected to, which is often combined, older age and health problems, as the death rate in the Philippines is 4 times the average of Northern countries. So that's a very big problem as well. And it benefited many people accused of drug offenses, since drug trafficking and drug trade and several drug offenses are over 20 years to life. So they have been incarcerated for a very long time. Many of them are very old. So this was an indirect way of benefiting, of addressing a different approach to addressing drugs or people who commit drug offenses through criminal justice responses, rather than directly focusing on a drug policy reform agenda. The third point, which is also relevant, is bail reform. We've supported the Department of Justice in implementing a very progressive approach to, in the Philippines traditionally, the more serious your offense, the more expensive the bail would be. That's the official guideline that was before. And we've discussed in several assistance meetings and exchanges that this was unfair towards the poor, which at a certain point, it doesn't matter how expensive the bail would be, it would not be affordable by then. So upon acknowledging what's called the indigency of the accused, bail has been cut in half or set at 10,000 pesos, which is roughly $200, whichever is less. So for indigent accused persons today in the Philippines, their maximum bail is $200. That's been a massive approach. Implementation is still gradual, I would say, but prospects are very, very interesting, especially considering pretrial detention is concerned. The fourth aspect I want to highlight is what this very interesting project is, as far as we know, this angle, innovative approach is a big innovation in Asia. It's called the Regional Layout Project. And this initiative aims to, because of the overcrowding, the lack of spaces for proper classrooms for education, the idea of implementing jail libraries, prison libraries, and allowing prisoners to access books in their cells, and compute time allowances, good conduct time allowances, as they're called, or remission, as it's also called in other countries, through reading. And that was a tool to do many things at once. First, create a big incentive for reading and education. The more you read, the earlier you can be released. So change the relationship of prisoners with books and education. They also higher levels of education, bigger prospects of employability and tuition, and all the while reducing overcrowding. We've supported the implementation of 13 new libraries in prisons, and a very, very interesting policy which we have to share as well, which is very adapted to the local context, where still few prisoners know how to read and write or have very high levels of schooling. So there are instances such as reading buddies of prisoners who are able to read a little bit more. They can read to the others, and these activities of collective reading orally and reading activities can be computed for revision, among other context-specific suggestions, such as having reading cards for facilities that can't actually have the space for a library, among others. So this is just a few pictures and a screenshot of the policy that was issued, and it's now being implemented in Bureau of Jail Management and Technology, that's the Bureau of Jail Corrections Agency targets and approaches for reducing prison overcrowding. And two specific actions have been included, which are very innovative for the country. The first is to introduce, so this is in the plans of government and all of government approach to create a non-financial bail system, which would include some sort of monitoring or approach based on the Tokyo rules at the pre-trial stage. So this would allow for a substantial reduction of pre-trial detention and to avoid excessive bail as a key tool to alternatives to incarceration prior to judgment by a court. And the second main item in the plan is to introduce periodic reviews of pretrial detention orders by courts. In the Philippines now, once someone is committed into jail under a commitment order by a court at the trial stage, that order is never reviewed, or it's not reviewed as practice, it's not established in any procedures. So there's also a commitment here to change the criminal procedure rules to include periodic reviews to assess the need to keep that person in detention, while going to trial. And this is understood with the discussion on this is based on the realization that people's lives are dynamic. So while you are in detention, you can get sick, you can get pregnant, you can develop other needs. The place that you've been detained might change. Overcrowding might have different impact. So it is important for judges and courts to be aware of the changing dynamics of prisoners in their lives so that they can determine appropriate measures according to these changes. I would end here. I apologize if I went over the time.
Oh, not at all. Not at all. Thank you so much. That was shukriya. Yeah, that was really great. Thank you so much. It's great to hear. I mean, a country like the Philippines, where it was quite a harsh drug policy. It's really great that you guys are doing this important work. To wrap up the panel, I think, yeah, just the question I was asking Ambika earlier, if we could circle around to that, and Ambika could give sort of her closing thoughts on policies that have been effective that step away from this punitive criminal justice system approach and go more towards public health and human rights, while keeping, and also the question about criminalization of poverty that I did mention earlier. I think if we could switch back to Ambika's presentation.
I think the alternatives is, I went through that in the, the PowerPoint, but I'm glad to see that we are speaking more about criminalization of poverty, and that is not just in relation to drugs, but generally. So there is even a global campaign to decriminalize poverty and status. So for example, what do we mean when we say criminalization of poverty? If you look at laws like colonial era laws, which many of our countries have in this region, vagrancy laws. So if you are homeless, if you're loitering, if you are, a street vendor, if you are homeless, if you are a drug user, then you are targeted under these laws. If you look at people who are imprisoned, and I had a, just here to show even now in Sri Lanka, if you look at the prison population in 2022, 64.1% of the total prison population was convicted for non-payment of fines. So that is criminalization of poverty. They are poor, they cannot pay fines, therefore that is deemed an offense, and you are sent to prison, which is also what contributes to the overcrowding of prisons. Now, the prison statistics also show that 63% of the total convicted population was convicted for drugs. The prison department doesn't ever give us the statistics where both intersect. So that is what I want, which I try to get through RTIs and whatnot. I'm not always successful. And also if you see in 2022, 47 persons were sentenced to death. Of these, 32 had an income of under 300 rupees, while 15 had an income of over 300 rupees per month. Once again, and this is something that JPP works on, people on death row are poor, and they end up on death row because they cannot afford competent legal representation, which is why they're on death row. So this is what we mean by criminalization of poverty, and I think it's really important to use this lens to look also at drug offenses, because most of the people who end up in jail are not the rich kids. It is those who are poor. And even the anti-drug operations, if you look at the Philippines, if you look at Sri Lanka, they target poor neighborhoods, arbitrary illegal searches in poor neighborhoods. I'd like to end with this because it's very, shall we say, inspirational. This judgment, once again, Canadian, where there is this, this woman who's called Miss Ellis. She had a partner who died of a drug-related illness, drug overdose, and she had 2 children. She herself was a drug user, had a drug dependency, had been to treatment 6 times, but was refused treatment also because she could not go through the screening. She did not pass the screening. When her partner died, she had to look after 2 kids. And because of that, she started dealing in drugs, very small quantity, only to about 5 to 10 persons, right? Because she had no other means. So here she was clearly arrested. And that is where this judgment comes in. So my question, how can we decriminalize poverty? This judgment, in a way, sets it out. That's why I would like to just read out portions of it. The court found that the current sentencing range in there fails to serve the goals of denunciation or deterrence. Now, once again, sentencing theory, crime and punishment, that those concepts are used. Since incarceration cannot address the structural factors that Ms. Ellis faces. A proportionate sentence requires prioritizing rehabilitation, which similarly cannot be achieved through incarceration, mandatory treatment, or any other punitive consequence regularly imparted by the criminal justice system. So, important point also about mandatory or compulsory drug treatment. Court is acknowledging it does not work. Instead, voluntary evidence-based treatment should be recommended by courts, but not required. Jail sentences do not deter or cure people who deal drugs to support their own use, but instead lead to overdose and death upon release. They are at increased risk of overdose death upon their release from jail. That is because while they may have been abstinent in jail, if they resume using drugs when released, they will have a much lower tolerance to drugs. Street-based drug dealers who work to ensure their own supply are the easiest targets for law enforcement because they do not have the resources to insulate themselves from detection. So it's not the large traffickers who are being arrested and imprisoned. They are expendable. So the people that are arrested, they are expendable and easily replaceable by those higher up in the drug hierarchy. So once again, goes back to also your first question, does the punitive approach work? No, it does not, and it's great to see that in a judgment. The court also said the criminal justice system has limited tools at its disposal to respond effectively to a growing health emergency, which in their context is the opioid crisis. So the court itself acknowledging that the criminal justice system really has, there's a lot of reform, a lot of learning and growth that is required. Of course, although her jail sentence or her imprisonment, the sentence was suspended, what has happened now is that the prosecutor last year has appealed the sentence. So even though the judgment was positive, progressive, we can see the state structure there. The prosecutor wants to go back to a punitive approach. But still, I think it's very inspirational. Thank you.
Thank you so much, Ambika. Yeah, that's a very inspirational judgment, and I think it'll take a while for Pakistan to get there, but hopefully we will one day. With that, thank you very much, everyone, for your patience. We'll wrap up the panel now, and I believe we have a short video, after which the Honorable Justice Shahid Jamil will deliver his closing remarks.
Looking at the prison population globally, around 20% of those who are currently in prison are there for drug-related crimes, including personal use and possession. This leads to serious issues concerning human rights protection and of course leads to overcrowding in these detention facilities, which in itself is a human rights violation.
What's really needed is for the global community to really understand that drug use is a complex medical and public health problem and should be dealt with within the health and public health system rather than the criminal justice system.
In this study, the working group called for the closure of all state and private mandatory drug treatment facilities that hold people against their will. Drug dependency and use must not be treated as a criminal matter, but rather a health issue and addressed with rights-based judgment.
Shahid Jameel. Justice Shahid is a Lahore-based jurist and a former judge of the Lahore High Court. As a lawyer, he was a member of the Lahore High Court Bar Association and Tax Bar Association. He was elevated to the Lahore High Court in 2014 and served until 2024. During his tenure at the Lahore High Court, Justice Shahid Jameel presided over numerous landmark cases, leaving an indelible mark on the legal landscape. Additionally, he played a vital role in the administration of the Lahore High Court. Sir, if you could please join us on stage.
Thank you very much. Assalamu alaikum to all. And my speech, which I prepared, was the opening remarks, but that has been converted into concluding remarks. But I'm afraid that I have not changed my speech accordingly, so you'll have to bear it out with me. So the idea was, which I have been thinking, that all these details shall come after my introduction of everything, and I'll try to take credit of things which are explained by Kadir Saab here, but things have been changed. So I'll start with the same tempo, and bear me out with this if it appears some relevant or repetitive in the sense. So, to praise be to Almighty Allah, who has blessed us with intellect, speech, and understanding. Thank you very much, Justice Project Pakistan, and Sara Bilal, the Executive Director, for giving me the opportunity to be part of the seminar and speak. As you all know, I'm not expert of the subject like most of the participants are, and after hearing them, I'm more impressed and feeling underconfident. So the reason why I'm here is that I, being a judge, have been hearing a public interest petition, and I heard it for about 4 years. That might be surprising for some of our guests from other countries, because here an idea where our administration does not work effectively. What the vehicle we have devised, the courts, is a continuous mandamus. So in continuous mandamus, we take up an issue and then we pass orders, and those orders are again then seen whether those are complied with in the next session or not. And it was a very long process in which number of people assisted the court. of them is Sayyid Zulfikar. He's sitting here. Probably Sara also appeared in one or two hearings. And Kadir Saab was there on every, and I hope in bureaucracy, the Secretary Saab, I'm sorry I forgot your name.
I'm Shazia.
Shaz.
From District Court.
You're from District Court, yes. So there are many people who were part of this continuous mandamus, and we have been able to get something amended there through the orders, which, and in particular in the prison. So I'll just explain it as I have written. The proceedings continued for about 4 years. In Pakistan, such proceedings are called continuous mandamus, through which fundamental rights are enforced by successive orders, compliance of which is examined in subsequent proceedings. Emphasis in the proceeding was on enforcement of fundamental rights to life of those who become victim of drug abuse, mainly because of its convenient availability at streets, educational institutions, and in prisons. During proceeding, the first thing noticed was lack of coordination between different departments. Therefore, Chief Secretary Punjab was directed to appoint a focal person for coordination and reporting back to the court. A committee of experts and lawyers was constituted for assistance of the administration. During the proceedings, the court was convinced that no policy shall work unless data of the victims at streets, educational institutions, and in prison is collected. So we have a PITB department in Punjab. It is Punjab Information Technology Board. That was also called, the director was called, and was directed to create a software where data can be fed from police station till prisons, and from wherever any drug addict in particular is reported, the data could be fed in hospitals as well. So the process was started. I'm not sure, Zulfikar Saab might tell whether that has been completed or not, but it was started at that time. Under Section 52 of Control of Narcotics Act, each provincial government is duty-bound to register all addicts for the purpose of treatment and rehabilitation. And under Section 53, the provincial government has to establish rehabilitation centers for treatment, detoxification, aftercare, rehabilitation, and social integration of the addicts. So the law was already there. What court did was implemented this. Rehabilitation centers are negligible in Punjab. Therefore, direction was given to establish the centers at divisional headquarters level was, but yes, the direction was given for creation of rehabilitation center at district level, but that was, I think that was, excuse was that there are no funds. So alternatively, on the suggestions which I received, the court directed that in each district hospital, there should be a ward, a section where these addicts should be admitted and they should be given treatment. Necessary staff was also directed to be appointed for the rehabilitation purpose also. In prisons, rules were amended to create health profile. This is very important. The rules were amended to create health profile containing basic information and to record any contagious disease or use of drug. For treatment of addicts and rehabilitation, district hospitals were connected with the respective prisons. It was pointed out that the kits are available, like these have just explained, but those cannot be purchased by the prison for testing the prisoners for lack of budget. as I already said, that there was lack of coordination between the departments. So if one proposal was accepted or carried, it could not have been made effective because the finance department will just refuse by saying that we don't have funds. So under the chief secretary, a committee was formed where all these proposals were put and they were made and directed to act upon by connecting all the departments. To integrate the information with main software, verification of prisoners through thumb impression from national database was ensured by inserting Rule 15A in Pakistan Prison Rules 1978. For schools, health profile was also ordered. That in school also every student has its preliminary health profile having basic information, but that was opposed severely by the parents because they didn't want that their child should be reported as addict, and that was not implemented. The order sheet, Sarah, I'll share with you the attested copy, and Zulfikar Saab is also trying to get the copy. I think if still though I'm not there, but it can be continued, the process which has started by you people. And so far the civil liberties, now coming to the topic which I just wanted to add here is that, and I am educated here for last 2 days, that basic thing which is required is the change of mindset. Firstly of the society, and then of the lawmakers, and then of the bureaucracy, that these addicts, the user of this substance called narcotics or drugs, they are in fact victims. They are not accused. They should not be convicted. And for them, the place is not prison. For them, place is a rehabilitation center. And rehabilitation center, as I have already said, is not necessarily one which is created under the law and which is funded by the government. In my opinion, the rehabilitation center in very inception should be his own home. Like it is pointed out that even the family start disowning such person, and then friends and the society at large, and maybe that is school or a department where he is working, because two factors. One factor that it is state's failure, I'll repeat, that it is state's failure that those drugs are available and sold at different points. And the second, failure of the society, that the person is under so much stress and under such a condition that he starts taking those drugs. So education is one of the factors that that society needs to educate themselves, and society needs to change the mindset up. Instead of hatred, the drug addicts need empathy and sympathy. Thank you very much.
Thank you so much, my lord, and thank you to everyone for joining us today. I'm sorry that we could not have a round of question and answers, but you can ask the panelists questions over lunch. It's being served at the back. Thank you so much.
Hello. 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 ठीक है वो जो आप टेस्ट वॉल्यूम होता है हेलो अच्छा भाई टू बी ऑन सेफ साइड जिनके सेलों ने मसला नहीं किया हमने वो भी बदल देंगे फिर देखें वो बाकी कर गए हैं तो इकट्ठे ही डले होंगे तो ये ना रन टाइम पे कर दें तो बदल देना मेरा प्लीज़ रिस्क नहीं लेना हेलो 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 अकबर आपको ही फ़ोन कर रहा था मैं ये एक बार भाई उसमें कॉपी हो गया है आप आ जाए हाँ आ जाए नहीं नहीं उन्होंने कर दिया बेचारी ने खाना छोड़ के ना पहले कॉपी बाकी वो उसकी अलाइनमेंट करवाएगी हेलो कितना टाइम लगता है कॉल कनेक्ट करने में आमिर भाई होगी कनेक्ट भाई वही वो इवेंट के नाम से साइड इवेंट है अब पता नहीं डे टू के अंदर कॉपी किया या रूट पे किया मैडम ने ये हेलो अस्सलाम वालेकुम रेड कोट क्या हाल है आपके नॉट एक्सेसिबल बेटा पोर्ट पटेल वो पूरी लगी हुई है एक मिनट दिखा मैं अपने लैपटॉप में लगा करप्ट तो नहीं वायरस तो नहीं हेलो आप सर कोई है नहीं कनेक्टेड बस है बात हेलो आवाज़ आ रही है आपको बाहर ठीक है हमें भी हॉल में आपकी आ रही है बट हमने ज़्यादा हाइड नहीं की हुई अब बोलो ठीक है, थोड़ी देर और बोलिए। ओके बेटा, ओके, आपको हमारी आवाज़ क्लियर है? गुड हो गया, आ जाओ अंदर।
If everyone could please be seated, we will begin shortly.
Hello, hello, mic test, hello. Hello, mic test, hello. Excuse me, sir. Can you hear us on Zoom? Hello. Sir, can you hear us? Thank you, sir. Yes, we can hear you.
Assalamu alaikum, everyone. Welcome back to Justice Project Pakistan's Reimagining Justice, a conference focused on public health and human rights-centered drug policy. We will proceed with our session on the incarceration of foreign nationals in Pakistan. This session will feature the launch of Justice Project Pakistan and the National Commission of Human Rights policy brief on foreign nationals incarcerated in Pakistan, highlighting key findings and addressing challenges related to their repatriation. We will begin the session by a keynote address by Ms. Rabia Javeri Aga. Ms. Rabia is currently serving as the chairperson of the National Commission for Human Rights. She is one of the most senior bureaucrats in the government of Pakistan and has spent 37 years in public service. She was the first female president of the Pakistan Administrative Service Association. She graduated from Mount Holyoke and then from the University of Oxford. Madam, if you could join us on stage, please.
Bismillahirrahmanirrahim. Justice Javed Sahab, Sara Bilal, Rahim Awan Sahab, Christine, my dear friend, my member minorities, who has really been my shoulder at the commission, all my dear friends over here. Today we really gather to shed light on a topic that often remains unspoken, the plight of foreign prisoners. These individuals face double jeopardy. They are incarcerated and they are separated from their loved ones. Imagine being confined within the four walls of a cell, denied the warmth of family visits, the solace of a familiar voice over the phone, or the hope of returning home anytime soon. This is the reality that many foreign nationals imprisoned both in Pakistan and across the world face each and every day. As of April 2024, more than 1,000 nationals from neighboring Afghanistan, India, and Iran are in jails in Pakistan. The majority have been incarcerated under the Foreigners Act. Approximately 66% are convicted, and 34% are still under trial. Despite the fact that all countries except Afghanistan have signed the Vienna Convention on Consular Relations, these prisoners face systemic challenges which lead to their prolonged detention. The challenges include delay in verification and identification. In the case of fishermen that we came across both in India and Pakistan, many don't have a national NIC. Many live in the remote coastal areas and you can't get to them. Limited consular assistance due to bureaucratic hurdles or strained diplomatic relations. Language and cultural barriers, and navigating a foreign legal system which you really can't understand. Repatriations are often delayed because of lack of transfer agreements. We have a transfer agreement in Malaysia that's been pending for some years now. All these details are within the policy brief that you will find on the desk over there. Now, NCHR is mandated to look into cases of detention and prisoners' rights, and we have been following foreign prisoners and the issue of foreign prisoners since the inception of the Commission for the last 2.5 years. We have been particularly concerned with the status and the condition of foreign women prisoners, which number 15 today. During our inspection, we sadly came across 2 foreign visitors, both suffering from mental illnesses, who had no recollection of their identities. One was from India and one from Tanzania. And because nobody could ascertain what their background was, these women's lives had been reduced to shadows, trapped in a sort of no man's land, destined to live their lives out behind bars or in a mental home. During our visits to Malir Jail, which houses the largest number of foreign prisoners, NCHR came across Indian fishermen languishing in jail for years, despite a consular agreement between India and Pakistan, which stipulated 1 month of return after proving the status and identity. And this is also despite a Supreme Court judgment of Mr. Dr. Justice Saqib Nisar, which calls for mechanisms to ensure the speedy return of fishermen. While NCHR found no evidence of cruel or inhuman degrading treatment among the Indian fishermen, what was sad was the time that had lapsed since the fishermen had been in prison, some as long as 5 years. The fishermen had been housed together in barracks. There are specific 2 fishermen. They have these big fishes painted outside. They were booked, and the whole launch was booked. So whoever was in that launch was housed together. This included old men, young men, a whole spectrum of people. They were all Muslims. They had come from Gujarat. And they survived by actually beadwork that they made, which they sold as tasbees, and they were able to buy soap and toothpaste and so on for jail. We had several meetings with the Ministry of Foreign Affairs and Interior, pushing on them and requesting them to ensure the repatriation of these 600 people. Pakistan always does it in reciprocity to India, and India had not sent any of our people back. However, I must say that the government of Pakistan took a proactive humanitarian approach and ordered the release of 650 Indian fishermen whose identities had been verified. The return process covered the whole of last year. It was conducted in 3 stages, approximately 200 individuals in each stage, and it was overseen by the National Commission for Human Rights in Sindh. And this was despite the Indian government's failure to reciprocate in the return of our fishermen. Now, this stance by the government reflected a strong and a positive commitment to upholding human rights and fostering positive relations between the 2 nations. However, when we speak of foreign prisoners, work is far from done, and a lot more needs to be done. And so I'd like to acknowledge the work that's done today in bringing together details, information, strategies, and policy guidelines for the way forward. In Pakistan, the issue of Afghan nationals needs to be streamlined, keeping in mind that women, children, and vulnerable groups continue to face considerable problems on their return home. A well-planned strategy with stakeholder consultation must be made public so that confusion and deep anxiety on the part of the Afghans can be allayed. Furthermore, the detention of Afghans in jails for months is unacceptable in the face of Section 14B of the Foreigners Act, which allows for deportation pending trial. Thankfully, today, there's only 1 Afghan woman in jail in Punjab. At the end, it is not about legality or policy. It is really all about empathy. It is about compassion and solidarity. It is about recognizing the inherent dignity and the worth of every human being, regardless of their nationality and regardless of their circumstances. When we talk of foreign prisoners in Pakistan, we must not forget the thousands of economically vulnerable communities of Pakistan prisoners held abroad. unable to afford independent legal counsel, and ignorant of the law or the language of the country in which they are jailed. This is where NCHR is now venturing ahead with the support of the JPP, international commissions, and local bar councils. We are looking to explore avenues to help our prisoners overseas, leveraging the power of local human rights commissions, because they have the power to visit areas of detention. We hope to develop partnerships between local human rights commissions and our missions abroad. Recently, we initiated a dialogue with the Malaysian Commission Suhakam, a very active and proactive commission that immediately went and visited our prisoners in Malaysia, and the Pakistani mission in Kuala Lumpur, looking to foster partnerships between these two identities. We have also met with the YPJ who are here, the Bar Council in Malaysia, who very kindly gave us time to help in a way forward to secure legal aid for our prisoners. I really would like to acknowledge your presence here. Thank you for being here. And really, their applause, because they're going out of their country, out of their turf to help Pakistan. Thank you very much for being here. These are the partnerships that are integral to ensuring the rights and the well-being of prisoners imprisoned overseas. In addressing the plight of foreign prisoners here and abroad, all of us present recognize the vulnerability faced by individuals detained outside their home country. By advocating for their rights and fostering international cooperation, NCHR, with strong partners, civil society partners such as the Justice Project, strive, and I acknowledge Sarah's strong role in this, strive to make a meaningful difference in the lives of those detained far from home, affirming our commitment to the protection of human rights and building a world where justice, but most of all, compassion prevails. Thank you very much.
Thank you so much, Madam, for those insightful words. We will now proceed with our panel discussion. The panel today is being moderated by Ms. Michelle Shahid. Michelle is the team lead advocacy and policy at Justice Project Pakistan. Her areas of expertise are drug-related offenses, capital punishment, wrongful convictions, miscarriages of justice, and the juvenile justice system. Michelle, if you could please join us on stage. Our first esteemed panelist of today is Dr. Rahim Awan. Dr. Rahim is the Director General of the Legal Aid and Justice Authority. He holds a PhD in law and has completed his LLM in international commercial law from the University of Bedfordshire. He has 4 years of teaching experience as a visiting lecturer of research and thesis writing to LLM students and law in action to LLB students. He also has 16 years of experience as a practicing lawyer, including district and high courts of Pakistan, and as an in-house lawyer in the UK and UAE. Dr. Awan, if you could please join us on stage. Our next esteemed and very dear panelist is Ms. Sara Bilal, who is the Executive Director of Justice Project Pakistan. Sara, if you could please make your way to the stage. And joining us on Zoom is Mr. Abdul Rashid. Mr. Rashid is a member of the Center for Criminology at the University of Oxford and serves on the Human Rights Committee of the Malaysian Bar Council. With an extensive legal career spanning over 2 decades at the Malaysian Bar, he currently holds the position of managing partner at Messrs. Rashid Zulfiqi, a prominent law firm in Malaysia. I now hand over the floor to Ms. Michelle.
Hello, everyone. Hello, can everybody hear me? Okay. Thank you so much for joining us today. So a little bit about this session. As the chairperson discussed, we will be, JPP and the NCHR launched a policy brief on foreign nationals imprisoned in Pakistan. Along with a discussion on foreign nationals in Pakistan, we will also be discussing Pakistanis imprisoned abroad, and particularly discussing the challenges that they face and the legal obligations of the government stemming from the Vienna Convention on Consular Relations and the Constitution of Pakistan, pertaining to both Pakistanis and foreigners in Pakistan. My first question would be to you, Sara. So I mentioned the Vienna Convention on Consular Relations. And so the Vienna Convention regulates consular relations between states. And Pakistan ratified the Vienna Convention in 1969. We also have the Constitution of Pakistan, and Article 4 of the Constitution speaks about due process rights. Could you speak to us more about the obligations of the government of Pakistan from these two laws, and particularly relating to both foreign nationals and Pakistanis abroad?
Hello? Okay. So, in a heartbeat, sorry, pardon my voice. In a heartbeat, Article 4 of the Constitution is the most important article. It talks about, and it's a very unique article in our jurisprudence. Very few constitutions around the world, I think we're the only one actually, that has such a provision. So most people think of it as the due process clause of our article, which says every citizen in Pakistan has a right to be treated in accordance with the law. But it also says wherever he may be. So that means that the constitutional obligation to fair trial due process is a right as a Pakistani national that travels with us outside of our country. What does that mean for the government of Pakistan? That means that if I am a Pakistani national and I go to Malaysia, and in Malaysia I am being tried, I commit an offense, or maybe I get arrested for an offense, and I am now facing the Malaysian courts, if any of my due process rights are violated, then there is an obligation on my government, the government of Pakistan, to make representations to come and secure my due process rights. This is a very, very progressive part of our constitution that previously wasn't looked at that much before the last 10 or 15 years. It's a very unique part because it says that my rights to due process as a Pakistani national travel with me wherever I may go. And if, for example, in a Malaysian court, I'm not provided with a translator, if I don't have access to a lawyer, we'll talk about Saudi Arabia. The most amount of prisoners, Pakistani prisoners abroad, are in Saudi Arabia. Under the Saudi system, you are not given state legal aid if you cannot afford one. All the proceedings are in Arabic. So, Pakistani nationals face a lot of hurdles in other jurisdictions. So having the clause, the article, the constitutional obligation really helps because it imposes a duty on our state to then make representations on behalf of their national whose rights are being violated. And we have seen our government do that very effectively in the past. I will give just one example, which was the first time that we came across the whole issue of foreign nationals, which was during the war of terror, as I like to call it. There were 63 Pakistanis who were being imprisoned, 43 Pakistanis who were being imprisoned in Bagram Air Base under US detention. As we all know, Bagram we used to call the evil twin of Guantanamo Bay. Those people had absolutely no rights. We didn't even know who they were. We just barely knew that they were Pakistani nationals. They had no right to a lawyer. They had no right to speak to their family. They were kept in the shadows. They were not even charged with an offense, and they were being kept indefinitely. So we went to the Lahore High Court and litigated on Article 4, saying that the government of Pakistan has an obligation to come to the aid of its nationals whose due process rights are being violated. And through that litigation over a period of 4 years, all of the Pakistani government officials went and they visited their nationals. They make representations to the United States government. They were forced to actually, the government of the United States had to actually, and then later on the Afghan government, had to provide what charges they had filed against them. And I'm really happy to say that after 4 years, all 43 of those Pakistanis came home, which was the largest repatriation from a US detention facility ever. But that happened because of our constitutional obligation duty under Article 4. So it is absolutely my favorite article of the Constitution.
Thank you so much, Sarah. So following from what you said, Sarah spoke extensively about the challenges that Pakistani prisoners face abroad. So my question to you, Dr. Rahim, is that one of the major challenges that Pakistani prisoners abroad face, and you mentioned this too, was about legal representation. And the Legal Aid and Justice Authority has the mandate to provide legal aid to Pakistani prisoners. So can you speak more about what that mechanism looks like?
Thank you very much, first of all, and the Honorable Mr. Justice Jawad Saab and Madam Javeri Aga and all the participants, Assalamu alaikum. We have discussed much about the mechanism of Legal Aid and Justice Authority with regard to the provision of legal aid within Pakistan. So your prime focus is provision of legal aid to the Pakistani national abroad is today. Yes, we were lacking behind the mechanism for provision of legal aid abroad with the JPP, and now we are extending our network for the purpose of extending legal aid to the Pakistani national who are incarcerated abroad. We have pitched a proposal to the Honorable Federal Minister that the Legal Aid and Justice Authority is ready to bear the expenses of provision of legal aid and repatriation of all Pakistanis who are imprisoned abroad. And as soon as we get go-ahead from the Ministry of Law and Justice, because the administrative control of Legal Aid and Justice Authority is with the Ministry of Law and Justice, we will initiate this activity. But one more, the most important thing is with regard to the Pakistani national who are imprisoned abroad is the consular access. And if we have proper consular access and our the counselors over there, they continuously visit these kind of detention center, the prisons, and they send us to reports back to Pakistan. That will make our life easy, and also for any authority working like the Legal Aid and Justice Authority and the National Commission on Human Rights, because we have our limitation to access to 200 countries wherever Pakistani people are. But in every country, we have our missions there, or the consulate there, or the High Commission, or the embassies are there. So it is prime responsibility of those missions abroad to enlighten us or share details of the Pakistani prisoners who are confined abroad, so that we can expedite these kind of activities. Thanks to JPP, the role of the counselor and the missions is being played by the JPP by sharing these data and other things with us. But before this forum, I'm making sure, inshallah, in next couple of weeks, we will get a policy decision to bring those prisoners back to Pakistan.
Thank you so much, sir. So following from this same discussion and about legal aid, does LAJA have a mechanism for providing legal aid, or is there a possibility of such a mechanism to foreign nationals imprisoned in Pakistan?
I'm afraid for the foreign national in Pakistan, our law doesn't mandate us. But during my frequent visit to the prisons when I was dealing with these Pakistani prisoners, I came across with meeting with the foreign nationals as well. And I urge the UN organization and other organizations who are working in relation to the refugees here, or the foreign prisoners here. And in many forums, I urge them that we are available for the secretarial support or administrative support within Pakistani prisons and with the Pakistani government if they want to play their role. Like, I guess, IOM and the NCHR, these are the main two bodies. I have spoken to them on many forums that to the extent of administrative and secretarial support, we are voluntarily ready to extend all kind of support, but rest of things they are required. And I was surprised when I talk about the Pakistani consular access to abroad, when I asked the Afghan national and other nationals whether their consular ever visited them, they said our consulars never visited them. This is the problem, and their embassies are also required to have frequent contact with our Pakistani jail authorities and the Home Department, so they are aware whether their nationals are there or not. Here, I would like to share a unique experience, might be of interest of Madam Javeri also. When I was visiting Quetta prison, the IG prison told me that here we got a female prisoner she speaks strange language. We are not aware about her nationality. She is imprisoned under the Foreigners Act. I said, how does she look like? Because from appearance you can get an idea whether she's Chinese or the Asian or authenticity of her. They said, no, we can't understand, and we can't understand her language. I said, okay, let me meet her. And when I met her, she was speaking Punjabi. And when I asked her in Punjabi, okay, where do you live? From where you are? She said, from Lahore. And my next question was about her whereabouts, her family, and I gathered much detail about her. And after inquiring from Lahore, perhaps she shared some sort of wrong data with me. We couldn't find her whereabouts. From there, I wrote again IG-Prison to share more data and ask her to share more things about her. But at least she was speaking Punjabi, means she looked like us. And I've been told she has strange appearance. We don't know her whereabouts, her nationality, and she's still imprisoned under the Foreigners Act. So who knows? And they were approaching Ministry of Interior for repatriation, and they were saying, we are not aware about her nationality, so Ministry of Interior also asking where to deport her. I said, deport her to Lahore.
Thank you, sir, especially for sharing the experience. Rashid, thank you so much for joining us today. Rashid has experience representing Pakistani nationals imprisoned in Malaysia. Rashid, could you speak to more about what your experience has been providing legal representation to Pakistanis in Malaysia? Rashid, you're on mute. Maybe we can... could you please hold on a minute so we can fix the... Yes, we can. Please go ahead. Thank you.
So 30 or 40 years, and there is also death sentence still available for the judge to impose. Most commonly, death sentence, the range of sentences between 30 to 40 years. No, sorry, imprisonment. So what we are suggesting now is that for Pakistan to also consider having a prisoner transfer agreement with Malaysia for those their nationals that are serving sentences in Malaysia to be sent back and to serve their sentence in Malaysia, because in Malaysia at the moment there is a prison overcrowding, and this is a good time to actually have that discussion, to start the discussion, because generally this discussion is lengthy and laborious, and this is a good time. I think quite apart from those who are on death row, there are also Pakistani citizens who are serving lesser offences, and this is a way that I think the Pakistani government can assist them. I mean, taking the cue from what Sarah has actually said, the obligation of Pakistan to actually assist their citizens abroad, this could also be construed as part of their obligation to have prisoner transfer arrangement to bring them back to their home country, so that they can serve their sentence nearer to their family. Because for foreign nationals, serving their sentences in Malaysian prison is quite tough. I mean, no prison is easy, but bringing them back would be quite a good idea. That's my 2 points for now. Thank you.
Thank you so much, Rashid. My next question is to you, Sarah. And Rashid also mentioned that the right to be informed, the embassies should be informed of their nationals' arrest at the time of the arrest and when they're detained. So following from that, this obligation also applies to Pakistan under the VCCR. So can you speak more about how the VCCR and the Constitution of Pakistan applies to foreign nationals imprisoned in Pakistan?
So both in terms of foreign nationals are also given a right under the Article 4 to be treated in accordance with the law. And then again, as you said, because Pakistan has signed the VCCR, the same Article 36 obligation to allow for the foreign national to communicate with their home ministry if they wish, with their foreign ministry if they wish, to present evidence in their defense, and to coordinate and contact them applies. But I want to speak a little bit to what Rashid spoke about in terms of foreign nationals, Pakistani nationals in Malaysia, and the British example. I actually began my career in Pakistan defending British nationals on death row. And I have an idea firsthand of the role played by the British Embassy, the British High Commission, in defense of its nationals here. No country is perfect, and doing these consular visits takes time. But I agree with Rashid that the countries that really actually make an effort and prioritize, especially what I saw with the British High Commission here, prioritizing those British nationals who are facing the death penalty as being higher up in terms of priority of who they visit in prison, is something that Pakistan should definitely take a page out of. I mean, let's be clear, the gold standard for assistance of their nationals abroad is Mexico. It always has been, and I think Mexico is a state that is closer to Pakistan in a lot of ways, and I think we have more lessons to learn from them. But I agree with Rashid that, if the Brits are doing a better job in Malaysia for their own nationals, it's something that us as Pakistanis can look to as a formula. But I also want to stress that, first it has to be a political priority. It has to be a priority that this is what we as a state believe in doing, right? And we have seen that when there is political will, prisoner transfer agreements have been prioritized and signed with even some of the most difficult states. We've seen Pakistan do that. So it needs to be a political priority. Number two, because it needs to be talked about in the public. There is immense public support for overseas Pakistani prisoners. We've seen that in our work over the last 15 years. Thirdly, you need to develop a system and an ongoing relationship with the detaining states' various bodies. So, for example, I've seen the British Embassy High Commission do a very good job in coordinating with police stations, in reaching out to the provincial home departments, in making sure that they have invested and built, invested, I don't mean money, but like, invested their time and effort in building that network so that the host state, which would be Pakistan, would inform the sending state, which would be England, if they have a national in their control. And I think that's what Rashid was referring to when he talked about the British High Commission doing a good job on behalf of their nationals in Malaysia. That Pakistani authorities need to be on good terms with Malaysian prisons, not just the inspectorate, but the various prisons where Pakistani nationals are kept, with the police officials in Malaysia, so that they know that, Pakistan cares about its nationals. If you have a Pakistani nationals, phone them up. And then also to do consular visits. In Pakistan, the embassy staff falls under the Ministry of Foreign Affairs. But the person that does the consular visits in the embassy is called a community welfare attaché, who actually falls under the Ministry of Overseas Pakistanis and Human Resource Development. I don't think that's a bad thing. I think that's a good thing, because when you have more than one stakeholder involved, I think you have more possibility to do more good. But, and I know that the MOPHRD has recently revised or revisited their policy for visits for counselors, community welfare attachés, saying what is the criteria under which they're hired, what is the skill set that we're looking for, and most critically, they've also looked and said, why do we have, for example, in Saudi, fewer community, or the same number of community welfare attachés that we do in the United States? We have millions of Pakistanis that are repatriated, and about, I'm going to misquote this figure, but it's the JPP figure of the rate of immigration. I think it used to be at some point 300,000, it might have gone up. So we need more community welfare attachés there. I mean, the chairperson has recently been to Malaysia, and what we see is that the Pakistani population in Malaysia is booming, out of control. And along with that will be the Pakistani population in prison as well, or falling afoul of the law. And that really requires a proactive stance and strategic. I mean, yes, we're always a country with limited resources, right? But I think that that should make us even more strategic and smart in how we apply our limited resources to get the maximum benefit. The prisoner transfer agreement is one, making sure that we have enough community welfare attachés, or, as the chairperson has spoken about and pioneered really, we build a network on the ground in that country between our institutions, whether it's the Legal Aid Authority and the Malaysian Bar Legal Aid Authority, whether it's between the National Commission for Human Rights of Pakistan and the Malaysian Human Rights Commission, whether it's between civil society and here. If we pool our resources together, which they're showing can be done, lawyers like Mr. Rashid and us collaborating, we can actually create a network that facilitates the capacity problems or helps solve the capacity problems that our state might be having in Malaysia.
Thank you, Sarah. So one of the things that stood out while both of you spoke, Rashid and Sarah, was about how the British High Commission or the British government really provides very good consular assistance and prioritizes people on death rows. In some countries, all right, my bad. But particularly those on death row. So Rashid, my question to you is that in Malaysia right now, there are 299, the latest reported figure is 299 Pakistanis in Malaysian prisons. And out of those, there are 24 Pakistanis who are on death row. And I think at least 10 of them are eligible for resentencing after Malaysia abolished the mandatory death penalty. So can you speak more about the resentencing process that will happen for generally and for these Pakistanis? What does that look like in the Malaysian courts? And also address what does legal aid look like for those prisoners?
All right. So the resentencing hearing has begun since November last year. And so what has been happening is that the court and the prison authorities and also the government have been filing applications on behalf of the prisoners. A total of 1,020 applications have been filed in court. So the hearing is being fixed, and the priority is given to prisoners who, depending on their age, over 70, 80 of our clients. So what is happening is that the court generally, insofar as drug trafficking is concerned, the prosecution is not seeking a death sentence for them, generally. So, but they do have a caveat. They would say that in cases where manufacturing is involved or it's a syndicated crime, then they may ask for death sentence. But generally, based on my experience, having represented the clients, they have not asked for death sentence, and the courts have given 30 years, and in cases where the individual is below the age of 50, no whipping, but no, sorry, for those who are over 50, there's no whipping, or women, there's no whipping, but for those who are 50 and below, they get at least 12 lashes. So that's number one. Number two, for those who have been committed the murder, then they may be sentenced ranging 30 to 40 years plus whipping. So for most of those individuals who are not represented by private clients, so what happens is that the court would assign a counsel for them. So what will happen is that the court will allocate a lawyer to represent them at the resentencing hearing. So generally, what a lawyer should do is basically they would have to interview the client, get their mitigating factors, but I foresee a problem involving foreign nationals, because sometimes the Malaysian lawyers may not have the capacity to speak the language of the national, right? So I can see that problem, and also to get the information, if they are not local, then to get the information about from their home country. That's where I think JPP can play a very important role within to represent the Pakistani national, because then they would be able to provide that information. But the problem is this: the time frame between the date of hearing and the date of being appointed is very short. So it could be range from 2 weeks to 1 month. So therein lies the problem, right? So I think JPP can play a very important pivotal role within the Malaysian context in the resentencing process, and I think quite apart from that, the court is aware of the principles to be applied, and I think the approach now is that if you can show that the person is rehabilitated, then it is likely that the sentence may not be meted out. But I do not want to jinx it, but that's how I see the approach being taken by the courts at the moment.
Thank you so much, Rashid. Thank you. My next question is to you, Dr. Rahim. The panel has spoken a lot about the challenges that Pakistanis face imprisoned abroad. So my question to you is that what reforms would you recommend for adequate legal representation and for legal aid for Pakistanis imprisoned abroad, particularly in protecting their due process rights?
One of the mandate of the Legal Aid and Justice Authority, we are also advisory body of the federal government and all government agencies on right to fair trial and due process of law. So we can make recommendations on these two aspects. Having experience of learning about the problems faced by the Pakistani prisoners abroad, and also the Pakistani prisoners in Pakistani prisons, say the overcrowding in the Pakistani prison, we have made certain recommendations which will address the issues of the overcrowding in Pakistan, not only overcrowding, but also humanitarian issues in Pakistan, and we have with just through some policy reforms, we can address these issues, and we have made some recommendations to the federal and the provincial governments on these aspects. Likewise, for the prisoners abroad, as I earlier mentioned, the key role or the key player is the Consular of Pakistan and the consular access. So we would recommend to the government of Pakistan, obviously when we'll compile the recommendations, We will add more things, but the key two, three things are the effective counselor access and representation, so that at very first instance and very first stage at the beginning of the arrest of the Pakistani prisoner, the government is aware about the arrest of a Pakistani national over there, and definitely when they will get to know, their family will also aware about the arrest and the charges against the Pakistani national. Secondly, as my learned friend was referring from there, the language barrier, the language issue. When you don't know the language of other person and other doesn't know your language and there's no common language between both of you, the issue is communicating and referring and mentioning your own version. How you will tell what were mitigating circumstances, whether the case is correct or not, what are your defenses. So one effective recommendation would be, with the counselor access, the lawyer or the representative who will meet the prisoner must aware of the language, where easily understandable to the Pakistani national, whether that's the Pakistani language or as I earlier referred, the lady was speaking Punjabi, and we've been told she speaks the strange language, she looks very strange. So the second important thing is the language issue. We must need interpreter for the Pakistani prisoners abroad, and that will be also ensured by the Pakistani mission or the embassy. And thirdly, being the only legal aid authority of the body having mandate all over Pakistan. We have certain provincial laws, though those authorities are not effective or functional, but on certain stage they could be functional. But the mandate of the legal aid and justice authority is the national mandate. So we will also ensure and we will request, whenever a Pakistani prisoner is arrested abroad, foreign or the government, the host government should inform Pakistani High Commissioner of the mission, and Pakistani mission notify through the Foreign Office to the Legal Aid and Justice Authority that this Pakistani national has been arrested under these charges, and these are his mitigating circumstances, are the defenses, whatever, so that we can take an informed decision whether that person is in need of the legal aid or not.
Actually, I just wanted to, thank you, sir, for saying that. I just wanted to add something that's in the policy brief that's jointly been published with the NCHR and JPP on foreign nationals imprisoned in Pakistan. There's a lot of statistics in there, and there's a lot of analysis of the statistics. And, well, there's not enough analysis of the statistics, but there's a lot of really good statistics in there. And if you look at the top nationalities of foreigners incarcerated in Pakistan in terms of crime, you see that the main acts that they're incarcerated for is the Foreigners Act, and it's mostly Afghans. And then you have the Control of the Narcotic Substances Act, and you see 119 of Afghans, and you see 41 Iranians. Then you have the Anti-Terrorism Act, the Control of Entry Act, the Penal Code, and then there's one called Unknown, there's a category, which is really interesting. I just wanted to say, because this is overall, the theme is drug policy and human rights. There is a theme that has been mentioned in the UN OHCHR's report that we've been talking about throughout, which talks about discrimination and who is actually arrested. And I know that in the report that they mention African nationals, like disproportionate kind of profiling of African nationals with respect to drug offenses. I think there's a really interesting parallel to be drawn here for Afghan nationals in our country in terms of profiling for drug offenses. And I'd be really interested, perhaps with the collaboration of the NCHR, to actually see and investigate further what are the particular needs of foreign nationals facing drug offenses here. The numbers I really remember when I last looked at them, I remember African countries like Nigeria and two others that were more prevalent in prison. But it's interesting to see that there's a lot more Afghans and Iranians being tried. And I know for a fact that a lot of the Pakistani nationals in Iran are there for drug offenses, some of whom have faced execution. So I think that is an interesting connection that's worth interpreting a bit more. This is our first, but I hope this is, with the support of the NCHR, this is an avenue that we continue to focus on.
Thank you, Sarah, and thank you so much, Dr. Rahim. Sarah, my next question is to you, actually. Yes. One last question. So this is generally about Pakistanis imprisoned abroad, and particularly where these prisoners are found. So in November of 2023, the Pakistanis imprisoned abroad population constituted of a little over 14,000. And in February 2024, the reported figures show that it's over 23,000. Now, there is a big jump in only a couple of months. So for a government that is already overstretched, and before I ask you the question, I would also like to highlight that close to, 74% of these Pakistani prisoners are in Saudi Arabia and UAE. And our data does show that majority of those are for drug-related offenses. And we do know that because there is majority of these prisoners are imprisoned for drug-related offenses and are also facing execution. So how can the government that is already overstretched address this issue?
Okay, very great. So I know these are official figures, but I think there's a confusion. Because I think I don't know what the confusion is, but I cannot believe that the figure jumped by 100%, like it doubled so quickly. So I'm still I know this is an ongoing debate, a ferocious debate inside the JPP offices about is this figure correct, but I think that they might be confusing immigration detention with prisoners, although I know that the figures that were given to the Senate committee specifically said these are prisoners. It baffles me. I've never seen anything like it, that there would be like a nearly doubling of it. We've done the hard part in these two countries, the UAE and KSA. The hard part was getting prisoner transfer agreements signed. We have those. But they need to be operationalized much more frequently, because what we see most often is that Saudi Arabia doesn't want 5,000 Pakistanis in their prisons. As we saw Ambika speak about the cost of giving even one person sentenced under drug offenses, up above 4 lakhs. Believe me, the Saudi authorities, and I've spoken to some of them when I went to Saudi Arabia, they don't want to keep Pakistanis under. It costs a lot of money. And, there needs to be a more systemic solution, the first prong of which was having a prisoner transfer agreement signed, but having Saudi lawyers, again, willing to represent Pakistani nationals. We've seen other countries practice this really well. In Malaysia, the Malaysian Bar Council has an agreement with the with Thailand that allows for the Malaysian Bar Council lawyers to be representing Thai nationals. There's examples out there of what can be done to solve this. We're not the first country to face something like this. So I think, yes, there are problems, but I think that there are really good solutions out there, and we've done the very, very hard part, which is diplomatically have, diplomatic negotiations for a prisoner transfer agreement. The rest of it, I hope with the pilot that we're doing in Malaysia, and I would like the chairperson to comment on that, that we can replicate it on a larger scale in Saudi or UAE or any other country where Pakistani nationals need it. Can someone please I'll give one.
So actually, I kind of panicked when I heard Rahim talking about that woman in Quetta. So I just messaged my office. But before I begin, I would like to thank our 2 parliamentarians who've come and joined us, and they make a substantive difference in the laws that we make. So thank you very much. So I'm going to read the message from Member Balochistan because I kind of panicked. Madam, one girl named Sonia was in Quetta jail, allegedly Indian, but during NCHR visit, we had a detailed interview with her. She stated that she is in Pakistan. She belongs to Lahore district. You're absolutely right. We have written letters and we have done investigation and communication with IG Punjab. And now the jail superintendent has informed that Sonia's parents have been found. The parents are now going to apply to the Quetta High Court for removing the Foreigners Act, and hopefully she will be released. NCHR Balochistan is following. So that kind of panicked me, so I thought let me just
ma'am, actually for the
Thank you so much to all our panelists and to Madam Rabia for her input. I think as a conclusion, everyone on our panel does agree that there has to be multi-stakeholder collaboration and there's no one entity that can address the issue alone. And as big as the issues are, we're not losing any hope. There is a lot to be done in this area. With that, I would like to open the floor for questions, and I would also like to invite the chairperson for a Q&A session.
Surprise, ma'am.
Please.
I think we have 15 minutes for a Q&A before concluding remarks.
If anybody has any questions, please, the floor is open.
And we've got JPPers walking through the aisles with mics.
Okay.
That will bring those to you. Oh, please stand up and identify yourself.
Okay, thank you, madam, for this in detailed discussion. I just want to add two things. One, I would want to respond these queries of Rashid Saab. In Pakistani law, national law, Transfer of Offender Ordinance 2002, we have the arrangement for those Pakistanis who have been convicted and sentenced abroad, and they can come back under this law to undergo their sentences in Pakistani prisons. Second important thing is those countries which have signed this extradition treaty, so the prisoners are allowed to send their sentences according to those terms and conditions. And two other important thing which we add, that is the troubles of foreign national in Pakistani prisons. First thing is, when the prisoner has completed his sentence, he or she is not released like a Pakistani national, and he has to remain inside the jail. And just to seek the clearance from the relevant country. In this process, because it is very tedious, he has to spend many months and years. So in this regard, as we know, under the Constitution, Article 10.4, there is a Federal Review Board. So under the Federal Review Board, there was a direction, and this alien rules have been passed. And now, anybody who is not owned by any country, and Pakistan issues alien cards, and he is allowed to work in this country. So these two developments, just I want to highlight it. Thank you.
Yes, that is Mr. Kadir Alam. He is the AIG prison. Is there another question? Not me. Yeah. Please raise your hand if you have a question, and someone will bring a mic to you.
Hi. Hello. It's working, yes. Hi, if there is a conviction under faith-based laws, there's particularly, for example, if there are certain laws in Pakistan which are not an offense in other countries, especially with related to faith matters, does the Vienna Convention provide any relief to those prisoners who can carry the sentence in their home countries?
So you shouldn't confuse the Vienna Convention with a prisoner transfer agreement. So the Vienna Convention, you know, Article 36 gives you rights for consular access and stuff. When it comes to serving out a sentence, those are usually bilateral treaties. A prisoner transfer agreement is usually a bilateral treaty that is signed between two states, although if I'm wrong, Ambika or David, please correct me. But for example, there is a model prisoner transfer agreement out there. The UNODC did a model agreement, and that's the one that Pakistan uses as the transfer of prisoners ordinance. And that transfer of prisoners ordinance gives the right for MOFA and the government of Pakistan to negotiate bilateral prisoner transfer agreement with another country. But that also means that countries can agree on any kind of, whatever's in the agreement is what applies. I think there should be some prohibitions on the agreement, on what needs to be in the agreement and what you can't exclude. But those are still gray areas. I know that the non-refoulement clause is always a part of the agreement, which means, you know, as a sending state, if I have a foreign national in Pakistan who is Nigerian, I cannot repatriate, I cannot transfer him to serve his sentence back home in Nigeria if there is a real risk of torture. So that's a duty that's posed on me as Pakistan to make sure before I return the national. Faith-based stuff gets tricky in the sense that if we have some laws that are faith-based, that do not exist in the country in which we are transferring them, and transferring that prisoner, then it becomes harder. But again, nothing prevents two countries from signing a prisoner transfer agreement with any clause attached to it, saying, this category of prisoners should be allowed to go. So it just, and we've seen that take place in other contexts, right, where the country specifically says, we'll take this person, even if they're a convicted prisoner, we'll take them back home. So it's a bit tricky. I did find out that Scotland has a blasphemy law. Yeah, she has a. The problem became that we have the death penalty for it, and Scotland didn't have the death penalty for it. But that was pretty interesting. We tried using. I think you know about this. That's why you asked this question. We tried using it. Malaysia. Any other questions?
Hello.
So there's one announcement that just now I got a message because I was messaging the jail that 39 Indian fishermen would be released on the 29th of this month. So Pakistan is going forward in releasing the fishermen. We need our people back from India.
Hello. You just talk about the prisoners who are in other countries. Why not who are in Pakistan, who are jailed in Pakistan? And what is the main reason behind it? And the ratio of prisoners are increasing day by day. Can you explain, please?
So we did talk about prisoners that are in Pakistan. You should have come to the first session. That was all about prisoners in Pakistan. But you can see a live stream of it. And what was your second question? Why are we not talking about prisoners? Foreign prisoners here. So the theme today is about, I think you're a student, so I just wanted to clarify, the theme today is about foreign nationals, so people from other countries who are imprisoned in Pakistan. What are the difficulties that they face? And then we've also spoken about Pakistani prisoners who are imprisoned in countries abroad. And the final question of why do we have so many Pakistanis imprisoned abroad? I think with the new parliamentarians here, I hope Parliament in the past has played a very active role, both the foreign committee and and also the Committee on the Interior and the Committee on Human Rights to get this information. So,
and also because there's so many under trial prisoners really languishing.
Thank you so much. We did raise issues like these, and for the fishermen that are, in India, there's a policy that they have to be sent back after some time. We do that, and they do that too. As regards to laws in Pakistan, I think Pakistan has most laws on everything. We have laws, but I think it's the implementation that is required. We need to focus more on implementation, making it happen, making it work. And that's the thing. Regarding drug trafficking in KSA, it's alarming to hear that the numbers, we will be taking this up again in the assembly now as I'm there. So inshallah, I'll be looking into that also. It's alarming. We do say that there should be awareness programs and people should be made aware of the strict imprisonment and the policies that they have in the kingdom. But the thing is, still they try and so the numbers has doubled is really alarming.
Actually, ma'am,
if I have got that right.
Yes, absolutely. So there are two reports that we've written in conjunction on this issue of Pakistani nationals being imprisoned for drug offenses abroad and specifically in the Gulf region. I would really appreciate a chance to actually perhaps approach and give you the findings of the report. But what we find, and this goes into the broader issue of this conference, which is drug policy and human rights. What we found through 10 years of different investigations into Pakistani nationals going to the Gulf is that the systemic problems that exist within our immigration processes here are the things that actually, the popular belief is that Pakistani nationals are, somehow involved in drug trafficking, but we found them to be victims of trafficking themselves. There were not drug mules by choice. They were preyed upon. They were vulnerable groups of people that were preyed upon because of a loose and lack of protections for safe immigration. And they were seeking legal migration, but were preyed upon by unregistered, unlicensed agents who have a network that is permeated or with drug traffickers. And so these were poor Pakistanis seeking legal migration who don't have any experience in going abroad. So there are solutions. It's not overwhelming. But I feel very strongly, because I've represented a lot of them, that we are not inherently drug traffickers or drug mules, or as a country or as citizens, persons that engage in illegal activity. We're just less protected. And once we know what the issues are, there are things we can do to make that better. So I'm really glad. Thank you for bringing this up. I really appreciate it.
Thank you so much, ma'am, and thank you to all our panelists and Madam Rabia for joining us. I will now hand over to my colleague Maneha. Thank you so much. Thank you, ma'am.
We will close today's session with closing remarks by Justice Jawad Hassan. Justice Jawad is a judge of the Lahore High Court. He is an expert on public and private international law. He has been actively involved in legislative and judicial reforms on the rights of foreign nationals incarcerated in Pakistan, child labor, domestic workers, and environmental rights. My lord, if you could please join us. Thank you.
Bismillahirrahmanirrahim. Lady parliamentarians, the Rabia, my law officer, Sarah, I've been asked to speak when I just came back to Pakistan. A topic I couldn't say no to. And I was just sitting here and she just mentioned that she brought a cake. And your last cake in the COP28 was very, very, very lucky for Pakistan. We were traveling to COP28 conference to speak on Pakistan's behalf with Senator Shari Rahman. And these senators with us, she gave me a cake at the airport. And the story of that cake is, after eating that cake, we had the speeches and Pakistan, mashallah, became the member of Loss and Damage Fund. That's a very big news. So today you bring a cake again to me? Okay. So let's start. Yeah. How we've been discussing, and I'm part of a judge, how Pakistanis are treated abroad, prisoners, and how foreign prisoners are treated in Pakistan. What is the constitution of Pakistan in light with the UN conventions, in light with the jurisprudence developed by Pakistani courts, has dealing with it. But I would have to talk about good news to you again and again. What is the stance of Pakistani constitution and how we deal with it? But before I set up, I have to give an overture or a prelude to what I want to say. My prelude to is that the concept what we've been speaking for us 2 days is a word about a person, and a person under international law, something very close to my heart, a subject called public international law. And you deal with a person like a foreigner. Sometimes you use the word overseas. Sometimes you use the word alien. Sometimes you use the word prisoner. Sometimes you use the word asylum seeker. Sometimes you use the word a hijacker. Sometimes you use the word, lots of various words of a person in international law. And the first topic of international law is, how do you deal with all these different categories of a person? Sometimes they call them native, sometimes they call them words. So first issue to deal with a person is under international law is that there are various international treaties, and that's not a treaty for last with the UN. Those are the treaties for the last 1,000 years. The Sulh Hudaybiyah of Rasulullah Sallallahu Alaihi Wasallam, the Treaty of Peace 1907, various treaties dealing with the prisoners and foreign prisoners. So my topic today is how international law looks into it. Pakistan has been a good country, making Pakistan being ratified to all the international hard law conventions and also policies also. Difference between a foreign prisoner in Pakistan and difference between Pakistani prisoners in foreign jails. I've explained that to you, but before that, I will give you a small story to share. They have this card. वो है मेरा card क्या है मुझे card discernible judgment का. They have been giving this. दिखाई दिया मैं पढ़ा वहाँ पे. So there's a card. I didn't know. The reason they called me because whenever they invite me, I said, why do you invite me? Because of your judgments. Judges speak through the judgment. There are only 6 judgments, and only by me, on the issue of what is an overseas Pakistani. And Sarah was mentioning Article 4. When we were setting up an overseas cell in Lahore High Court, because Pakistan at the time of 2019 were only getting $18 billion as a remittance from abroad. And those Pakistanis were not happy what we were doing to them. They're coming back to Pakistan, the property they bought had a qabza. They're coming back to Pakistan asking for some plot, not given the plot to them. They said, we earn money, we send money to Pakistan, and what are our rights? Do we have a right in Pakistan? And first thing, I looked into the Constitution, which I'll show you how I looked into the Constitution and share with you. And I found Article 4, and I gave the judgment on that, which says, because the most powerful articles of the Constitution is, because this Constitution of Pakistan, it still starts with the word of Allah, which says, whereas the sovereignty of the universe belongs to Almighty Allah alone, it is sacred trust. The concept of sovereignty is very private in public international law. Every country is sovereign. Nobody can tell me कि मुझे मेरा कैदी छोड़ दो, and nobody can bully me to say, please release it, because I am a sovereign country. I am a Islamic Republic of Pakistan. And I can't dare say to any country to release my prisoners. Every country under international law has their own national laws. So what I linked into is Article 4 of the Constitution, which says is the 2 most powerful words used in the Constitution is, one is inalienable in Article 4, which says to enjoy the protection of law, it's an inalienable right of every citizen to be treated as per law, and no action determined to a life, body, reputation, property for a citizen wherever he may be, comma, for time being in Pakistan. Wherever he may be, he can be abroad, comma, for time being in Pakistan. The framer of the Constitutional had a vision to say Pakistanis might be abroad. A Pakistani can be in Pakistan. So that was clarified when we set up the overseas cell in Pakistan, Lahore High Court. We traveled to all over the world to speak about that come to Pakistan, invest in Pakistan, you are protected. And good news is, in 2019 we set up that, and by the time 2022, the foreign remittance to Pakistan of the overseas went to $2 billion. Last year, it went down $2 billion more, only less is $30 billion. Because they want that I want to be protection. Now, how did I protect them? The reason was this judgment which you have in the sticker, where it says that I just discussed that you can be treated because you're an overseas Pakistani. And you, wherever you be, and that was then dealt by, a very good trick was that to be dealing with the Pakistanis, to protect their rights, what we did was that if they're outside Pakistan, how can we examine and what can we call them? I'm a very orthodox, conventional judge, and I don't want to use the word which you use in English. I'm sorry, the Constitution doesn't use the word overseas. The Constitution uses the word under under 4th schedule of the Constitution is the Federalist Part 1, and the Federalist Part 1 has Clause 3. And Clause 3 very clearly states that the Parliament can make law on the external affairs implementing treaties for the immigrant or immigrant. Immigrant who goes out of Pakistan, EMI, immigrant, and immigrant who comes into Pakistan. When you read the words of dealing with prisoners, you use the word, oh, they're diaspora, immigrant Pakistani diaspora. You have to look at the culture anthropology of the law of the countries. You have to look at the sociology of human beings, how they're treated in a diaspora in the world. When you look at the political science of the world, and you look at the economic sciences of the world, you look at the legal anthropology of human beings, how the countries have been dealing with the other countries, because every constitution of a country is different. Every country in the world is different. The world legal system is divided into 2 basic parts. the common law countries and the civil law countries. Some countries have adversarial approach, some countries have inquisitorial approach. That's what the basic fundamental principle of that countries are. And so how we dealt with it, so we opened the door and we gave 6 judgments. Tahir Chishti, who is overseas Pakistani. Your rights are dealt, you're outside Pakistan. Your rights are dealt inside Pakistan. Then they gave a judgment of Tahir Mahmood, again, that Article 4 mentioning this. But don't you know, most important is give and take. If you ask for a right to be treated, there is a duty on you, which Sarah mentioned, is inviolable obligation. Article 5. Article 4 and Article 5 are intertwined. If I'm asking for my right from you, I have a right to be protected by law, by the state and the courts, but do you know what? I have a duty to obey the Constitution. It's an obligation on me to obey the law, and loyalty to the state is my first fundamental principle. Article 5 says it's an inviolable obligation. Inalienable means a birthright. Inalienable means a right is your inherent right, which I have to be protected by law. But Article 4 is inviolable. You can't break that law. You have to obey my Constitution, and you have to obey my loyalty to my Constitution. So these 2 words opened up with these judgments, went over, talked about, and JSSP found out that these are the judgments. They said, I want you to speak on them. Now, how are they dealt with? Pakistani, we'll talk about Pakistani prisoners abroad. How are they dealt with is they can say that if it's an obligation on Pakistan government to have, because we have ratified VCCR, we have ratified various international treaties, we have also ratified various international covenants of civil and political rights, the Generation Declaration of 1948, we have ratified all these hardcore laws of the UN. But how Pakistani are dealt with is, they can be dealt very carefully by the basic organs of the state, because Pakistan Constitution divides the federal government and provincial governments in 2 parts. Article 90 says there'll be a federal government, and federal government had rules of business, and those rules of business in 1973, there is a division of the immigration, there's a division of the overseas Pakistanis, interior, and there is a division of the foreign office. They can ask them to have them, give them, protect them, to have the consular dealing with those issues. They can ask the government to have their rights because they're sitting abroad, and if they file a petition, if the government doesn't do it, where shall they go? That's a question which I'll answer later, and the good news I'll give you, I've also answered that in a judgment, is can Pakistanis come to Pakistan or have somebody come to Pakistan and say, I am in a jail in Birmingham, can you help me out? And the government is not helping him out because he's a Pakistani. Pakistani means he has a passport of Pakistan. He's not an alien. He's not an immigrant. He's a citizen of Pakistan. He's not an asylum seeker. He's not a person which is called a refugee. He's not like Julian Assange, who is an asylum seeker in the world, who is living in Ecuador, embassy in London, not to be tried. He's not a person who doesn't have to do things. He's a person who wants to know what he is. So he will file a right petition. I have been dealing with those cases in the Lahore High Court. And we will hear those cases. We are hearing those cases. That's the question to answer you. Can he file a petition? Now we talk about the foreigners in Pakistan. My persons outside Pakistan, and they are called foreigners. Somebody called them overseas. Somebody called them non-citizen of Pakistan. Somebody called them the different languages they use, or outsiders. Somebody called them whatever language they use, you want to use. Those are dealt with Article 10 by the Federal Review Board. In both, the protection is again by the judiciary. A non-action of the government, I will explain at the end how the judiciary comes into play and protects those rights, and are protecting the rights. I give the judgment of Justice Masuli Shah, the judgments by Supreme Court asking the authorities to do certain things for Pakistanis. But on the other hand, there's a Federal Review Board headed by a senior judge, Justice Yahya Afridi, Justice Sadakat Ali Khan, and another judge in Balochistan. That board only functions under Article 10 of the Constitution, which deals with safeguard and arrest of detention. That Article 10 is the outcome of the Pakistan ratifying the United Nations Declaration of Human Rights 1948. Pakistan then signing and ratifying the United Nations Covenant on Civil and Political Rights 1966. Pakistan then incorporating those rights into the Constitution of Pakistan from Chapter 2, Part 1, from Article 8 to Article 29 of the Constitution. And those Article 10 is very clear, which deals with, and the word is a very sensitive word they use, that if there is a foreigner convicted in Pakistan and the sentence is finished, he can allowed to go back, but then under the Foreign Act, he cannot go because certain reasons. It's all within the ambit of a country, because country has everything with it. Pakistan government is a sovereign government. They have their own, every country has their own policies. Every country has its own laws. You saw Al-Fayed, the duties, Al-Fayed, the Fayed of the Harrods. He had every money in England. He had Harrods, he had the football club, he had every sports, he was donating, but he didn't get the passport of UK. He fought all his life and died as a citizen of Egypt in London at the age of 92, 2 years ago. He fought all his money to get the passport. And he never got the passport because it's a country are all independent. They want to be independent and sovereign countries. If you countries had independent, it's their own policy. The policy of the Interior Ministry, the policy of the Home Ministry. So you cannot ask a country what to do. Country has their own policies as per what they want to do. So first thing is, our Federal Review Board is a review board which says that no law providing for prevention, detention shall made except deal with the person acting in a manner prejudicial to integrity, security and defense of Pakistan. But what it says, and no such law shall authorize detention of person for period exceeding 3 months unless appropriate review board have affording opportunity. Review board meets after every 3 months. Headed by Justice Yahya Afridi, they meet in Lahore Registry, they meet in Karachi Registry of Supreme Court, and they meet in Islamabad Registry of Supreme Court of Pakistan. And they hear cases, they review, and they sometimes extend, sometimes they ask them to repatriate, and sometimes they ask for the medical treatment of these prisoners. And that's something which is as per the Constitution, a mandate of Article 10, a review board is there. So again, one side, the Supreme Court and High Court judges are doing with it, looking at the Pakistan Foreign Act, the Foreigners Act 1946, dealing with those issues and sending lots of prisoners back if they are there with the permission of whatever the law is, subject to what the law of Pakistan is. And on the other hand, we are dealing with a lot of cases like this under Article 199. Article 199 of the Constitution has 6 words to play around with. Sometimes the Constitution is silent and says every person. Article 9, right to life. Article 9, right to life. Article 19, right to life, right to speech, is to a person. Person has to be a Pakistani as per Article 260 of the Constitution. But sometimes the word used in the Constitution is individual. Article 10A, right to a fair trial and due process of law. Sometimes they use the word citizen in the Constitution. Sometimes they use the word a child in the Constitution. Sometimes they use the different words in the Constitution. But can a foreigner court come to Pakistani courts? That's the question. Can Pakistani overseas can come to our courts? Can a foreigner can come to our courts? That's what I want to ask. How much Sarah has taught you so far? My answer is, I told you in the beginning about the word overseas, who may be a person is the word used under Article 4. Sometimes you use the word citizen. Sometimes they use the word a child. Sometimes they use the word individual. Now, foreigners in Pakistan, will they be fitting into the word person? Can they be a citizen? Can they be an individual? Can they be a child is the word used also in the Constitution. So how can they approach a Lahore High Court? Because Pakistan has 5 high courts, and their high courts are functioning under and they hear the writ petitions of writ of mandamus, writ of certiorari, which is under Article 199. Who can approach our courts? Can they approach our courts? The word used in the Constitution as a person defined under Article 260 as a person to be a citizen of Pakistan. The word used is a citizen. The word used as an individual. The word used is some different words. The answer to is what? Whether an overseas can come to Pakistan, he's living in London, can he come to a court in Rawalpindi or Sambal High Court or Lahore High Court or Sindh High Court? No. PLD 2021, Islamabad 304. I know that. I'm also passing a judgment. And we are not, yeah. We are hearing this case. No. No. So that's the news I want to give, because I don't want to give you those news so hurriedly. The word you'll be using is, because the Constitution, the framework of the Constitution has chapters. Constitution has parts. Constitution has articles. And the Constitution is a beautiful Constitution with various amendments. The Constitution is talking about human, Article 4, to enjoy the protection of law. Any person is used. Article 9, right to life. I'm speaking here right to a speech, that every person has a fundamental right to speak, expression, and free press. Right to exploitation, right to movement out of Pakistan, inside Pakistan. Can foreigners say that after Article 15 and I enjoy my right to go out of Pakistan and come into Pakistan? Because that's a word used in Article 15, to come in and out of Pakistan. They're all fundamental rights, but all rights are used with the word person there. And person under Chapter 1, Part 2 are defined under Article 260, means a citizen of Pakistan. Now, the word sometimes they use individual. Every individual has a fundamental right to a due process of law, to a right of fair hearing and due process. So there's individual. So person, no. Pakistani ko hona chahiye. Individual, no. Citizen, no. Now you are my officer, sit down. Every day in the court, he is in my court, he's defending the provincial government. He's a federal government employee. Both are not, now, tomorrow I'm going to give you a bad time, because now you're not, keep it. So he's a federal government employee, he's a assistant advocate general Punjab, he's a federal attorney general of Pakistan. See, you have Kamosh, ji. Yes, so because in the beginning when I came, she heard me while having a coffee. So no, ye rondi hai. Article 199 says, that's what the framework of the Constitution, put a beautiful Constitution like the American Constitution. Article 190 says, subject to the Constitution, comma, any party, if aggrieved and there's no effectual remedy, comma, may make an application to the High Court, semicolon, to direct a person to do required by law to do, to refrain a person to do not required by law to do, to declare any act done, proceeding taken, to protect a person from habeas corpus, and to have a person. So word is party. The catch is party. Party means anybody. That was I defined in a judgment in the Plenary bench, is PLD 2023 Lahore 164 Zafar Khizr case. That these words are intertwined. They are intertwined words. Some words are interchangeable. When there is a requirement for the ease of law, they are interchangeable words. So the good news is foreigners can come to Pakistan. Foreigners can approach to our courts. They can say that I am in the trial through a petition that I want you to be tried and I'm going to have my trial early. What is the issue is? Because this WCCR was even discussed in the Jadhav case in ICJ, Pakistan versus India. And these are the international issues, these are international law, international cases, and every country has their own rules, every country has its own regulations, and every country has their own priorities, and every country has their own policies. And we cannot interfere in any of the policies, we can only refer to the settled principles in the world. Because some principles, because this is an international topic, this is a topic of the international law, and international law is a law which is all built and dealt with the principles of the law, and under Article 38 of the International ICJ statute, The first is the customary practices. Second is the judgment of the ICJ, and then the writings and other principles. And these are the principles every country has to follow. But again, they're all self-sovereign. So my question to you is that to conclude that Pakistan enjoys a good reputation in terms of international law. Pakistan has been a country which has ratified, complied, signed, acceded to various international conventions regarding human rights. Pakistan is a country always in forefront of complying with the mandatory requirements of international law. Pakistan is the country which is in every fora from climate change to human rights, to child rights, to women's rights, have signing and showing progress in the world. Pakistan is a country, as Madam said, we have so many laws. It's a country which after ratifying some treaties is under compulsion to make a law. And most of the laws in our country are all outcome of the international law. Most of because Pakistan is the true translation of the delegated transformation theory of international law, unlike France, Germany, which have a monastic view. The international law is a law for the country, but not in my country. My country has to sign it. It has to then bring it to the parliament, to the parliamentarians, then ratify it later on. Then they have to accede. They have to file as instrument. Then they have to bring a law. They have to bring authority to show the world that I am a good country. I am doing the mandatory requirement of the law, and I have the courts to do with it. And also, when sometimes executive is not so effective, the parliament is not so effective, sometimes judiciary plays its part. To conclude, in environmental field, when two organs failed, judiciary led it, as you know, in climate justice. In human rights, in child labor, judiciary of Pakistan and South Asia was always leading in the gray areas where the government was silent. Government didn't know what to do. And this is the only thing we have. When we go internationally, I was just there in Doha with the International Conference of Commercial Court Judges with Justice Shah. We always look good because first issue is the world is now divided internationally when you come abroad is north and south. And now in the climate change, north is falling south. We have learned from northern countries, western principles, western articles, western charters, western treaties. But now they're learning from our approach of courts, how we progressively deal with issues. Thank you.
Thank you so much, everyone, for joining us on day 2 of our conference. Dinner is served at the back. You may proceed. Thank you.